25.
25, my lord. I have filed an IA, my lord, for impleading ourselves as the party respondent, my lord. Yesterday I have filed, my lord. Or may kindly be called for
Today?
today, my lord.
Okay, call it.
Lordship, with regard to item number 10, with the consent of other side, I would like to mention it, Lordship. Here, an appropriate petition has to be filed, Your Lordship. Appropriate petition has to be filed, Your Lordship. The petitioner has expired.
It is submitted by
S.
the
Gautam. S. Gautam.
as Gautam learned counsel for the petitioner that the petitioner has in the meantime expired. Accordingly, they would like to file an application for implement of the legal years of the petitioner.
Lordship, I'm petitioner in person. Last couple of days, I'm physically not well. My IA meter is fixed on coming 9th of September this month. So I may not be physically available to attend the court. So I want legal some postponement.
9th.
I may not be available because not in a position to appear because due to health reason. So I'm postponement up to 16th of this month.
That cannot be done because record is not with us. We'll have to pass an order that can also be adjourned.
My
So you can make a mention. We'll allow it. We'll pass that order. Okay, give it to him.
Because
9th.
I cannot appear in who.
No, that we understand. We give it to the.
No advocate.
Yes.
May I please, Lordship?
Yes.
Lordship, item number 17, Lordship. I may withdraw this matter. Lordship.
Item number
17, Lordship, 17.
The learned MS R. Wrongmay, learned counsel for the petitioner submits that she has instruction to withdraw this petition. Full stop. Accordingly, read petition stands dismissed on withdrawal.
So, is your Lordship? Lordship, supplementary item 62 and 63. Lordship, there has been some subsequent development. So, I have obtained instruction, Lordship. Can the matter come up after 3 weeks, Lordship?
Okay. MSA Talukdar learned counsel for the petitioner submits that there are certain subsequent developments which may be necessary to be incorporated in the present petition. Accordingly, she prays for an adjournment. You have taken consent?
Lordship, I have taken consent.
Prayer is not objected. Full stop. Accordingly, matter stands adjourned and will be listed after 3 weeks.
Much obliged, Lordship.
Before motion, item 61.
Who is the employer? A petitioner. PWD. Who is representing PWD? Huh?
He is coming, man.
Yes, Mr. Gogol.
That's my. Yeah, nothing, but maybe like it.
What is your instruction?
There is a specific format uploaded in the tender.
No.
And my lord, as per clause, Lordship, may kindly turn to page.
No, his whole case is that I was a responsive bidder. My price bid was open. I was the L1. Then what is the reason of withholding?
Page 55.
Page
55. Clause 13.2.
Page 50. Just a minute. Clause
13.2.
13.2.
The second para. The bidder must quote his bid price in section 6. Form of bid. Both in figure and words, which is to be duly signed by the bidder. A financial bid without any mention of bid price in the form of bid shall be treated as non-responsive and shall not be considered for evaluation.
So according to you, though he was technically responsive, his
technical part is different. Now we are in
financial. That is what I'm saying. So though he was technically responsive, he is not financially responsive for want of this clause. This is what you want to say?
Yes. Because, my lord, we cannot deviate from what we have, my lord, mentioned in the NIT.
That's important.
And Lordship will kindly have a look at, my lord, for a moment. Lordship will kindly have a look at the form of bid submitted by the petitioner here.
This is
the format that was uploaded.
Which page?
Lordship will see at page 138. Page 138, and Lordship will kindly compare with the form that was uploaded. Specific column space has been, my lord, indicated in the form. Here, my lord, nowhere it has been mentioned. And when we say that, my lord, if this figure is not there, along with, my lord, in words, it will be rejected. It will be declared as non-responsive. Now, can we deviate from this particular clause that we have ourselves, my lord, put in the, my lord, NIT? It's not about, my lord, whether it's technically viable or not.
So according to you, 138 is the financial offer.
Form of bid, yes. Now, Lordship may kindly turn to 141 for a moment. 141 of the 141 of the, my lord, writ petition. The one of the bidders, my lord, there are three, my lord, three bidders, financial bidder open. Lordship will see they have mentioned the other two bidders, 141 and 144.
Where is the price? Where is the price?
In 144, my lord, in para 1, third line.
No, no. According to you, this form of bid is prescribed.
Yeah.
Where is the petitioner's form of bid?
138, page 138. Lordship will compare with para 1. We offer to execute the works described above and remedy any defects therein, conforming with the condition of contract specification, drawing bills of quantities addressed for the sum as quoted in the price bid. Nothing is mentioned.
Now, how you say you are L1? Where is the price?
My price is, your lordship will find 148. Page 140, my lord.
140.
This is my price, my lord. 11 crore 89 4.
140.
Yes, my lord. Total in figure.
It is BOQ, item rate of
Yes,
BOQ.
yes.
Where is the price code?
Form of bid.
Quoted this price, my lord, in BOQ, my lord, that has been accepted. Your lordship, that is why I am submitting before your lordship. Lordship, kindly give me 3 minutes, my lord.
No, not 3 minutes. We will give you 30
Yes, my lord.
minutes.
Your
Yes.
lordship kindly
Now
go-
we understand. That
Yes,
is
my
why we wanted to know, because
Yes,
you
my lord.
projected that you are the L1.
Yes, my lord. He has said specific clause that should be followed. That will be kept in mind, my lord.
Hmm.
Lordship, kindly take this written submission, my lord.
What written size you have motion stays?
Wrong, my lord. It is-
You want to have written English?
Yes, my lord.
Yes.
Lordship, kindly look that document, my lord. Thereafter, I shall show your lordship what is happened, my lord.
Hmm.
Mike, you cannot reappropriate for the same time.
So
If you-
do you dispute? We'll hear you. Just we
Yes, my
understand.
lord.
Do you dispute that that page 140 is not it? 138 is your price bid.
I never dispute that my rate which has been quoted in the
No,
one
no,
thirty.
that is your price bid, and
is my price bid.
page 40
Yes, my lord.
page 40
Yes, my
is the item rate of BOQ,
Yes, my lord.
in which total is your price.
And that he has given format. Your lordship, kindly look to the format, my lord.
Hmm.
Bottom, there is no page number, my lord. That is the game, my lord.
No, form of bid, where do we get this? This is part of tender document.
No, my lord, no, my lord. That is,
Huh?
I
Huh?
want to submit, my lord. I saw, my lord. If your lordship give me 10 minutes,
Okay.
then he submit, my lord.
Yes.
Otherwise,
No,
what
we-
happened, my lord?
No. We want to know the facts
Yes, my
to
lord.
understand. Yes.
Otherwise, my lord, tomorrow, my lord, tomorrow, if this
No,
tender
let us be today.
Yes, my lord.
We'll go
My
to
lord,
tomorrow.
no
later.
one can submit the tender, my lord.
Yes.
That is why I, my lord, given.
No,
So,
just
lord-
I wanted to know.
Yes, my lord.
I wanted to know whether the form given by Mr. Gogoi is part of bid document.
Not my lord.
Okay, fine.
Yes, fine.
That is what we wanted.
That was subsequently they uploaded and it will be filled manually. It's an unencrypted document.
Mm.
So all the person can look that document and there is a condition of the contract. At any time, earlier bid can be withdrawn and next bid to be given. That is nullified exercise of power.
Okay.
That is why I write it. Yes, my lord.
Let us understand. the fact.
Yes, well, respondent number submitted an incomplete document under section 6 form of bid.
Hmm.
Have you lordship got it? There's
Yes.
no witness, no digital signature or address. In respect of digital signature, there is a condition of the contract. You have to put the digital signature in that particular document.
Okay.
Yes, my lord. Your lordship kindly go to the there
form of bid, my lord.
Which page?
Yes, my lord. Page
So-
144.
Page 144.
Lordship, come to the bottom part.
But we wanted to first understand that your fulfillment, then we'll go to the
The
others.
reason behind it, why I am not putting this rep, my lord, because this is a malified
We'll
exercise of
see,
the-
we'll see their discriminatory behavior,
Uh,
but just we want to say that you have satisfied, that's all.
Yes, my lord.
Or then we'll see that whether in similar circumstances,
Yes, my lord.
relaxation has been given to
Yes,
others.
that is the my submission. Yes, my
Therefore,
lord.
first we want to know
Yes, my lord.
what is your defect in your tender.
Yes.
Now, whether similar relaxation has been given to others, let us see that. So that's why I'm asking, let us first understand the form of bid. Admittedly,
Yes.
according to them, your form is not with this. Now, for that, we'll have to understand whether this is an essential form,
Right.
whether this is a part of the
Yes.
bid document. Let us see.
Of the part of the bid document. Because if your lordship go from page number 118 to 133, all the bid document has been mentioned.
Mm.
And that document is not available with the tender. Subsequently, what happened? This document has to fill up manually without my lord
Where is
password.
that notice manually filled up?
They have satisfied your lordship that a document which has been manually uploaded without password, it will be looked by all persons.
So
That
it-
is my case, my lord.
So therefore,
Yes.
according to you,
Yes, my lord.
when you submitted the bid,
Yes, my lord.
there was no format prescribed under the bid. Is it your
Yes,
case?
yes, my lord.
So according to you,
Yes,
when you submitted the bid,
Yes, my lord.
there was no format
Yes,
as
my lord.
produced by Mr. Gogoi
Yes, my
on
lord.
submission of bid.
Yes, my lord.
Accordingly, you have submitted the
Yes,
bid.
my lord.
Thereafter, subsequently, they have notified, not notified.
I don't know. It was not
So-
notified. The
so
document
you
is not
do- so
notified.
you
It
do
was
not know.
notified.
It might be subsequently notified, so
No,
therefore.
my lord. It is not within my knowledge whether it is notified or not, because in
So,
tender
so
document.
this is an afterthought. Subsequently, this notice was prescribed.
Yes, my lord.
So if you can satisfy, why should we go to who has done what?
No.
So
That is the reason.
Uh.
And he has said we have strictly followed the condition of the tender.
therefore,
That is why my humble submission before
we are satisfied your argument.
144 pages, my lord.
Hmm.
The person.
That is to respond number 10.
Ah,
We'll come to respond of
that-
the letter.
my lord, if your lordship not look.
Do you
together-
say that you have not fulfilled?
My
If
lord,
according
I
to,
have fulfilled.
so let us not go to the others first. We'll go to that. Yes, Mr.
Because he
Gogoi.
said, my lord, he has followed because this document.
Now,
that's what
now
this is
show
the
us for
document.
the tender bid document uploaded in the web portal that this is a part of the bid. That's all. That it was a part of bid.
In the motion, my lord, says this is something I could gather, my lord. If anything detail is
Okay, we'll
required.
take it up. till
Monday,
then.
my lord. On Monday.
Apparently,
My lord, I am.
My lord, lordship, why I'm saying is,
intake that. we'll-
lordship will kindly, my lord, appreciate this. In page 144
Hmm.
and in page, my lord, 141.
Hmm.
The other two bidders have given the.
No,
in the
other
same
two bidders
is it
might have
possible
given,
for
Mr.
three
Gogoi,
bidders-
listen to us. Other bidders may give it. What we want to know is that whether this is an essential part of the tender. You will give to form in this way. If that is there, then question will be, then you will be at liberty to, that
Take a
this
call,
is,
madam. Yes, of course, madam.
we'll insist on this
Yeah.
because this is our form.
Yes, yes.
Until and unless you declare your price, how do we know that? You have a good ground then. But there is no prescribed procedure. You have not said, and you now say that this is a form, this is his case. Then it will not be it will be an after subsequent change.
My direct reply to that is, my lord, so far as the other two bidders, they have also submitted this form of bid.
So you will.
No, why I'm saying is, my lord, is it possible for three bidders to submit, my lord, three form of bids in the same language, my lord, with the same format, same comma, full stop, everything, my lord?
No, we do
Unless and until
no,
that
we do
particular
not know.
format.
That cannot be a ground for writ
No,
petition.
I'm
that
just saying.
somebody
I-
has
I
done
would
it, so
also-
therefore this is with the correct principle. This is not. You
Because,
show
my
us
lord,
that
in-
this is
yeah,
our
yeah.
document, we will insist on, we will insist on that.
That, my lord, I have already
Okay.
placed.
Okay.
I will have a written instruction, my lord. I will place it that this.
No,
particular-
just show us from the bid document that this is a part. This is the page so and so of the bid document. That's all.
That is
But
fine.
why I'm saying is, my lord, in page 80, admittedly, even my lord, page 115, lordship may kindly see.
Mm.
It is blank otherwise. So I have also, my lord, raised a query to them. Why, my lord, page 115, section 6, form of bid, it is blank.
So therefore, we'll,
It was uploaded,
why
it is uploaded.
so therefore, form of bid, if it is there, in the bid document, matter ends there.
Yes.
Then his other argument that I have been, this is a curable defect, you
No,
have
no,
cured
that
defects
won't
for,
come, my lord. It's very clear. my lord.
no, no,
Non-responsive.
his
Yes.
argument. Then also he'll go to, why should he go to defect
Yeah,
of
only, my
respondent
lord,
number 10?
limited, my lord, point is
Until
that-
and unless he can satisfy that, yes, I was correct. Why should he go to respondent number 10? On this point, either he is inside or outside.
On Monday, my lord.
Monday.
That- that-
Don't issue anything.
But there I.
Yes.
That may be recorded, my lord.
My lord, need not be recorded. I am assured
My
I will
lord,
call them right
There
now.
is a man of the involved only what will happen, my lord.
It will continue,
That
my
will
lord.
be
That's why I'm saying, my lord. Lordship will say, my lord, Lordship will
I'm
consider
not
the
saying, I'm
interim
saying
way
not finalize the
Monday.
tender process.
Okay.
That is,
Uh,
I'm not asking just that.
The present writ petition is filed assailing that though the petitioner's bid, the bid submitted by the petitioner in respect of NIT dated 4/7/2024 for construction of 33 kV dedicated HT line from 132 kV Pavoi GSS to BCM and H campus with laying of.
Lordship can take away two, my lord. I can satisfy your lordship, my lord. It will come. I already.
We do not know, Advocate General is waiting. Monday.
My lord, Monday.
With BMC H campus with laying of 33 kV armored cable on railway track crossing, etc. Submitted. However, however, petitioner even being responsive in technical bid and being the L1, his bid has not, he has not been awarded the contract till date.
Just declare L1 by
Huh?
the document.
Has declared L1, his bid he has not been awarded with the contract. Full stop. None appears for the petitioner on call. None did represent the petitioner on 4/3/2024. However, another opportunity was granted to the petitioner on 4/3/2023. It was further observed that it was further observed in this court's order dated 4/3/2024 that if that in case of further non-representation, appropriate order will be passed. Also, accordingly, the present petition stands dismissed for non-prosecution.
Item 42.
None. None appears for the petitioner on call. However, in the interest of justice, matter stands adjourned and be listed after 4 weeks. Lifted after 6 weeks. Yes, next.
Item 43.
May I please?
Yes.
My lord, this is regarding my lord non-payment of my lord victim compensation to the petitioner.
Yes.
And my lord, this is a cover case, my lord, by the Honorable Court, my lord, identical issue
Where is that?
has been decided. Lordship will find at page 46.
Yes,
Page 46.
46.
Property part, my lord, page 47. And my lord, direction part, lordship will find at page 49.
This
last-
is ex gratia. What?
Ex gratia. Victim compensation. Victim compensation.
Okay, victim compensation.
Page 49, last paragraph, my lord.
When died, when judge convicts the acquittal,
Dated, my lord, by judgment and order dated, my lord, 16/5/2019.
16/5/2019. Any order in the judgment
Yes, my
for?
lord, we have annexed the order, my lord.
No, you have annexed. We understand. I have asked you a question whether any award was there.
No order was awarded.
No order was passed by the
Trial court.
trial court.
Yeah.
No order. Then when have you lost this claim before
My
the?
lord, claim loss, my lord, on, my lord, my lord, 25/2/2020.
25/2/2020. What happened thereafter?
Thereafter, my lord, no response was given. Matter is.
Heard.
May I submit, Lord?
Yes.
I am appearing from the District Legal Service Authority. They have informed that they have not received any application from the petitioner.
Then file an affidavit. The case of the petitioner is that because there are many provisions, it's not that simple, though we are passing order.
Correct.
Under the scheme, there are prescribed period when you'll have to file application. What is
Okay.
the limitation? Because it cannot be go on. We understand the agony of a victim. We understand that victim is having a right, but sometimes right extinguishes.
Now, in
Will-
view of the,
will-
my lord,
No,
decision, my lord, Suresh case, my lord, it is, my lord, clear that delay and application is not immaterial. the application.
Since yes, they can stand,
Yes.
let us,
Now, my lord,
but you
application.
will
they
have to
have-
file affidavit.
I have the instruction. Lord.
Otherwise, you know,
But-
if for your delay, if matter is delayed, is deprived of the money, then
Otherwise,
interest is to be paid by the person who for whom this affidavit is
I'm
being.
representing district legal service authority.
Maybe whosoever, we do not know.
There in
Before this court, his legal authority, whosoever, some equal, all equal.
may submit Assam State Legal Service Authority have some standing counsel lordship. Their name also not shown.
Then how can you say that you have received instruction?
No, from the we have received from the district legal service authority.
Who is standing counsel of district legislature?
RS Sodori, Rakesh Sodori.
Legal service is a party?
Yes.
And my lord, page 41 lordship will find acknowledgement received by the state legal service authority. Page 41.
Okay, we'll go to that. We'll go to that. Since a point, let us understand here, MS Chaudhary. It is submitted that MSR H. Chaudhary is the standing counsel for the Legal Services Authority, Assam State. Then how can she represent the district legal service?
I'm representing this level
Why then Assam is required?
because they have filed before Assam State Legal Service Authority.
Oh, they have filed before
No,
Assam
no,
State.
no.
You should file before the district.
Yes, my lord, as per the provision, my lord, it can be before the Assam as well
Okay.
as the district.
Okay, Kikul. Submitted at MSR H. Chaudhary, learned counsel is the standing counsel for Assam State Legal Services Authorities. Full stop. The application seeking what do you call it? Victim compensation was filed before the State Legal Services Authorities. Full stop. Therefore, the stand of the State Legal Services Authorities shall be required in this matter. Full stop. However, her name is not reflected. However, the name of the standing counsel is not reflected in the cause list. Full stop. Accordingly, registry to list this matter on when we can dispose it of on next give a date 12th of September 2024, reflective name of MS R.H. Chaudhary as the standing counsel of the State Legal Services
Developed.
in the admission column. Who need to file affidavit?
We have filed. They were to come, Mr. Lord.
None appears for the petitioner on call. Though an affidavit has been filed by the respondent number 3. No, way back on 23/11, respondent number 3, way back on 23/11/2023, and no reply has also been filed. Full stop. However, considering the interest of, I've already evicted,
Lordship, there is no stay order on cause.
no stay order, it was a Bhavan, I think, constructed already.
That's what I don't know, but
However, in the interest of justice, matter stands adjourned and be listed on, give a date before, in this month. Not 27, before that. 24th of September 2024.
45.
Please, Lordships.
Mm.
Lordships will recall a similar matter being taken up on Monday, Lordships. And it is about unlawful construction over a Patta land, Lordships.
Okay.
It's the same person.
Okay.
The land belongs to the same person. This pertains to the concrete wall, a temple being constructed in the place.
Okay, it is submitted that the similar cases are fixed
On the first of
On-
October,
On first of
110.
first of October, being WPC,
WPC, the other one is 3986 of 2022.
3986 of 2022. Full stop. Please this matter along with the aforesaid petition on
File no affidavits have been
will be
filed.
on the first of
October,
September
October, Lordship.
or first of October. In the meantime, the circle officer may file their affidavit in opposition, clarifying their stance in this regard.
Deeply obliged.
It is your lordship. In this case, we have to file rejoinder affidavit. Lordship, some more time may be given.
MS R. Chaudhuri, learned counsel for the petitioner, prays for and is granted
2 weeks, lordship.
2 weeks after it will come after vacation, 4 weeks time to file reply affidavit to the affidavit in oppositions filed by respondent number 5.
I'm deeply obliged.
List accordingly.
Item 47 and 48.
That's it. We have to file a reply. But it's ready in 2 weeks time may be granted.
Okay, Mr. Goswami, learned counsel for the petitioner, prays for and is granted 2 weeks time to file reply affidavit to the affidavit in opposition filed by state respondents. List accordingly.
Applies. Interim order to continue.
Interim order pass earlier shall continue till then give a date. A list accordingly on 25th of September. Interim order pass earlier shall continue.
49.
May I? please? My lord,
Yes,
my lord, the impugned my lord award lordship will find at page 29.
award is challenged under 226. Why?
My lord. Because the my lord claim was my lord rupees 28 lakhs. And my lord, they have awarded my lord only 13 lakhs.
Awarded by whom? Ombudsman. Okay.
Page 29.
This matter is ready as regards service as the respondent number 1 and 2 has entered it. 1 and 2 has notice upon respondent number 1 and 2 has duly been served. Accordingly, list this matter in the admission column when after 4 weeks.
Developers.
Item 50.
Please, your lordship. In this matter, respond number reports, new address I have collected. I may be allowed to take fresh steps on the new address.
Okay. MS Chakraborty, learned counsel for the petitioner submits that she has been able, the petitioner has been able to collect the proper address of respondent number 4 and accordingly she prays that she may be granted
3 days time
5 days time to take fresh steps upon respondent number 4
on new fresh address.
in the new address. Prayer is allowed. List after 4 weeks.
Item 51.
May I please your lordship.
Yes.
The writ petition has been filed to set aside the illegal recommendation and selection of the respondent number 5 as L1 bidder in response to notice inviting by the respondent number 3 and 4. And this honorable court had issued notice 17/11/2023 upon the respondent.
What is the work?
Is that, my lord, the petitioner along with 2 advocates that had visited to the office of the respondent number 5.
No. What is the subject matter?
That illegally the respondent number 3 and 4 selected the respondent number 5 for cleaning and sanitation service to Assam Medical College. And
You also participated.
I am the petitioner.
No. Did you participate in the tender process?
Yes.
And your tender is in rejected and award is given to whom?
Respondent number 5.
Respondent number 5.
Yes, he is not eligible. There is a eligible
Okay,
criteria.
notice is served upon respondent number 5.
Notice has been earlier, we have take step upon the respondent number 5 register post with AD. Thereafter, as per Lozima Court order dated 19 to 2024, was delivered to the addressee on 12/12/2024. Lozima Court order dated 19/2/2024. If my lord may peruse. As per Lozima Court order dated 19/2/24, notice in respect of the respondent number 6 was delivered to addressee on 12/12/2023. The Lozima Court order dated again 19/2/2024 directed the petitioner to
Yes, who is for the health and family welfare? SC Health and Family Welfare. Bring them. We'll ask them to serve. Yes. After some time. Yes.
Item 52.
None appears for the applicant on call. The present application is filed for restoration of WPC 4102/2022, which was dismissed for default dismissed for non-prosecution by an order dated 3/6/2024. However, none appears for the applicant today. Have be it as it may, in the interest of justice, matters stands adjourned and be listed after be listed on give a date. 17th of September.
Item 53.
Yes, your lordship.
Yes.
Lordship, unfortunate state of affairs, lordship, the council's fee has not been paid.
No, my lord.
Lordship, there is an order 11, the order.
Yes,
11
let Mr.
I have taken my lord.
You are in the same boat.
Exactly, my lord. I have called up everybody, my lord. I have instruction, my lord. It has been sent for FS proposal, my lord. Financial. So, my lord, it will take some. It's belong to my colleague, my lord. Even when
Not
the
only colleagues, someday you may be in the debt.
exactly, my lord. I know, my lord. So, my lord, I have called up the
So there
commissioner.
may be clash of interest. You arguing this case.
I called up my lord commissioner and told him that you do it immediately, whatever has to be done. So, my lord, there is movement, my lord. It has been sent for financial purpose.
Mr. R. Dhar, Learned Standing Counsel for the PWD, submits that so far relating to payment of lawyer's fees, which is subject matter of the present writ petition. FS proposal has already been forwarded to the Finance Department on 25/6/2024 for concurrence, and they are awaiting clearance approval from the Finance Department. Yes, where is Finance?
Finance is not a party in this case.
Not a party, call for somebody. Full stop. At this course, though Finance is not a party, this court has requested Mr. B. Gogoi, Learned Counsel. Yes, Borpujari, are you Finance? Mr. R. Borpujari, at this court has requested Mr. R. Borpujari, Learned Standing Counsel for Finance Department, to obtain instruction as regards the status of approval of FS proposal within bracket FS/PWB all capital /25/2005 amounting for an amount of rupees 237,500 35,000 for an amount of rupees 2,35,000 37,500 full stop. List this matter.
1 week, next week, my lord.
We do not want an instruction. We want that, my lord, it has been done. That's all.
No,
So
but-
maybe after 2 weeks.
No, Lordship will kindly appreciate, this is for financial sanction.
Sanction.
Sanction is not within our domain. If it is selling proposal, my lord, then everything is complete. We
Now,
cannot
now sanction, who will give the?
sanction, otherwise, my lord, if the authority is with the administrative department concerned. Anyway,
Now,
I will
why
check.
then they have written it to you? Or?
I will have to check.
My lord, I don't know, my lord. They have,
We do not know.
the department says that it is the finance, they will give sanction.
Let
Then
me
let it
get.
take.
List this matter on next week. Even.
Lordship will kindly fix
You
it.
clarify it.
No,
Then we'll get hold of this officer.
Lordship will kindly hear me.
Yes.
I will take instruction on the strength of this letter.
This come.
And Lordship will fix a short date, maybe the next Wednesday, my lord.
Next
I will
Wednesday.
get
List
it,
this
I will get
matter
it.
on
No
success.
difficulty.
Registry to reflect name of Mr. Barbugari in the
Yes.
court list. You are not a party, but we have
No,
requested.
I will get it, my. He is our own brother, colleague, my lord.
No, I say that everybody may be in the same place
My lord,
tomorrow.
when the writ petition came up very fast day, my lord, prayed before this court to dispose of the matter.
Yes, next case.
Obliged.
Lordship, non-compliance of order dated 21/7/23.
Where is the order?
My lord, page 9.
Page 9.
I think payment of ex gratia,
Hmm.
ex gratia payment.
Lordship,
Unit.
yes, your Lordship. Lordship, the matter relates to payment of ex gratia.
Mm.
So I had, with regard to the matter, I had the talk yesterday with the concerned official. So they told that they will obtain the ceiling by 28th of this month.
Okay.
So may I pray before your Lordship to kindly grant some time.
Okay. Mr. B. Deuri, learned counsel for the respondent, submits that he had a verbal instruction
Yes.
from his client that the payment to the petitioner is the process of payment to the petitioner is at an advanced stage, and ceiling, financial ceiling
Yes.
can be obtained by
By 28th date to inform me.
28th of September 2024, and therefore he seeks further time, 2 weeks time to complete his instruction. Prayer is allowed. List this matter on give around next October 1st,
Yes.
31st
Yes.
of October.
Yes.
May be shown, my lord, in both
Petitioner's name not shown.
not shown. Advocate.
If you do.
Obliged.
Obliged, your Lord.
Please, your lordship, my lord, this
Yes.
is for vacating the interim order, my lord.
You have filed interim vacation petition. This is IA.
Yes, my lord.
Where is the interim order?
Page 99.
Page-
101 is relevant, my lord.
Page 99.
Yes, my lord. And the relevant portion, page 101.
Any objection filed? No.
No, my lord.
Lordship will file our objection, Lordship.
You have taken time since long.
Yes, last chance may be given, Lordship.
You have taken in the month of May. Is that it?
Yes, Lordship, last chance, Lordship. A week time may be given. Lordship.
Okay. The learned counsel for the opposite party writ petitioner prays for
1 week time.
a week's time to file objection. Full stop. Such prayer was made on 17/5/2024, which was granted. Be that as it may, considering the prayer, the adjournment stands allowed. And as allowed, full stop. List this matter on 28th of September. Full stop. The opposite party may file objection in the meantime. If no such objection is filed prior to the aforesaid date, the IA shall be taken up on its own merit and on the basis of available material on record. None appears for the petitioner on call. However, in the interest of justice, matter stands adjourned and be listed after 4 weeks.
May I please, your lordship?
Hmm.
Lordship, in this case, during the pendency of this writ petition, your lordship, respond number 3, respond number 4, and respond number 8 died, your lordship. So, your lordship, due to delay in filing substitution petition order 22 rule 4, your lordship, the suit has been abated, your lordship.
Suit?
The petition, the petition has been abated, your lordship. And
Nowadays, writ petition also abates. Yes, anyway, then
done, your lordship, I have delayed, your lordship, to file to set aside abatement order, your lordship, under 22 rule 9, your lordship. So section 5 petition is there, your lordship, before your lordship, for hearing, your
now
lordship.
tell us from when all this CPC is made applicable to writ petition.
But one order was there, your lordship, to prefer to
Write down in writ petition. What is your grievance?
Yes, lordship. The thing is that, your lordship, the private response is constructed some building, your lordship, that is the municipality area, your lordship, without permission from the municipality board, your lordship. That is, even, your lordship, we approach the municipality board to issue eviction notice, your lordship, frequently, your lordship. Though, your lordship, they not even responded, your lordship. For that reason, your lordship.
So
the
according to
petition-
you, the other party has constructed, made
on
illegal.
my land, on
your-
my
your
land.
own
Yes, lordship.
Now, who will determine that? Suppose other party has
Yes, that is-
constructed illegal house in your plot of land.
Yes, sir. That,
Who will determine that?
that civil court, your lordship.
Then
I understand, but the thing is that the statutory provisions are there, your lordship.
statutory
In the-
provisions are there for
the-
other purposes.
but-
For the purpose of that building is illegal. For being violative of municipal
So
bylaws and rules.
municipality board.
It cannot be decided that somebody has enclosed, constructed a building in somebody's. They cannot, they have rightly not entered.
But there is a, with due respect, your lordship, there is a provision in the municipality.
What is that municipality provision? Tell us. Let us also know.
Though I'm not prepared on that because.
So you
I-
must be prepared. This is
Yes,
a
lordship,
matter of
because, the
2020.
3 petitions are there impeding and substitute.
So
lordship.
these are unnecessary. We are closing all this petition and we are hearing it right now. These are unnecessary to delay the matter. You go and file a civil suit, seek declaration and recovery of possession matter ends there.
Land grabbing cases there, your lordship.
So land grabbing
Pending-
case is there, proceed the land
pending,
grabbing.
your lordship, but because some statutory
are-
provisions has been violated, so lordship may kindly fix. the
No,
date.
no, nothing doing. What is the statutory provision where a land grabber or a civil dispute, a building can be demolished by municipal authority? Then no civil court is required. Yeah, I will go and say that he has constructed land in my building in my plot. They will verify and say that, okay, this is your land.
Because, with you, my grievance is not about the private respondent, your lordship, the municipality board, the municipality. board is
Understand,
not
municipality
done of
board,
your
they
lordship.
rightly not acted. So we are deciding this. Since you have already gone to the court under land grabbing provision.
Lordship, kindly fix a date, your lordship, so that.
At 2. Go bring out that legal provision. Let us also get enlightened. We may forget on Monday. We want to be enlightened. What is the provision authorizing municipal body
Lordship.
to demolish a house in these circumstances? At 2.
Last lordship.
Yes,
Regarding item number 58, Lordship,
that has gone long back. Yes,
my name may be recorded.
yes, next case. Yes, what is this?
Lordship, in this case, petition wants to engage the senior counsel. Lordship. Let the matter be listed in next week.
Who wants to, why this application is filed?
Early hearing. Lordship.
Early hearing.
What is the subject matter?
Lord, petitioner's bank account has been freezed, Lordship.
When the account seized by
Bank account has been freezed by
item number
60.
supplementary. Okay. Okay, give a date.
Next week, Lordship. Next week.
Yes.
I need a.
What is your issue? What is the issue?
This is the freezing of the petitioner's bank account, Lordship,
By whom?
by the bank authorities.
By the
On
bank.
whose request?
On the
On the
request,
request of the
request of the post officer in charge in police station. Also, yes.
Under her, under the offenses were relatable to which section? Okay, the present IA is filed for already rule issued or what?
409, 420 and 460.
In the writ petition rule issued?
notice on issue.
In the writ petition rule has already been issued? Or notice has been issued?
Notice has been issued.
Then why you are filing an early hearing petition? The present application is filed for early hearing of WPC number 5541/2023. Filed by the applicant. Full stop. The matter is ready as regards service. Pleadings are complete.
Complete.
Huh? Pleadings are also connected. Writ petition is ready as regards service and pleading. And therefore, the matter be listed. Accordingly, the IA stands allowed by directing the registry to list the connected writ petition for admission hearing on, give a date. Twenty-fifth of September 2024. Full stop. IA stands disposed of. Main writ petition in view of the order passed in IA so list this matter on so for admission hearing.
Finding item 61.
Yes, later.
Hilton, standing complaint. I have respondent number 6 is the private respondent.
Notice served. Notice you have not, okay.
Notice the petitioner along with other.
Wait for some time. We'll ask them to serve the period is for how many years?
5 years, 5 years.
5 years. Are you sure?
And I'm not confirmed.
Why then you make a submission?
Sorry.
What is the period? You don't have the brief.
I had the period.
Tell us, what is the period of the contract? Generally, it is for 1 year. Might have become infructuous.
Page number 20 is the.
Page?
Page 20.
Okay. We'll wait for some time. Let the health department standing counsel come. Yes, next case.
Item 1.
To keep it in item number.
It is better. We have already filed affidavit, my lord.
We are adjourning this. We have already informed AG. We'll take up this matter just before vacation.
Before.
Okay, conclude it. We may take it up on 4th of October. 4th of October. On that day, AG will also be there in
Yes,
other cases.
Obliged.
On the prayer of the learned council decision.
Item 2.
Lordship, Lanet PB Amphophonics
He was here.
was here, Lordship, yes, just now, in court number 26, Lordship. So, can me to list the matter on the vacation regarding the SOP, Lordship.
Otherwise, my lord, our case is already.
Your case, then we want that this to be corrected.
Yes,
That's much.
Yes.
We can close this also, since they have taken a decision.
Wait for him, Lordship.
May I please, your Lordship? Lordship, I am appearing for respondent number 2.
Okay, list this matter again on the prayer of learned public prosecutor. List this matter again on 1st of October.
Interim order to continue.
Interim order pass.
I am obliged.
We'll hear him, the other part.
Yes. Well, in that case, my lord, cost should be also important.
Item 3.
My lord, please see the order sheet. This writ is pending since 2015. 9 years had gone. The government respondent had not filed any affidavit on last.
Who is respondent number 6? Respondent number 6. Yes, Mojumdar.
6 is senior sub-register. 6 is the order dated 30th May 23.
Affidavit is required.
Affidavit is required. What has happened in this case? There is a reason why affidavit was not filed for such a long time. 2015, when the petition was moved, my lord, interim order was refused. This writ petition is filed challenging an order passed under the
That we know. That
fixation of ceiling on the annual lease act. They are in occupation of excess land. Now, writ petition is basically directed against the order under section 20, but then their plea is that on the one hand, you are asking for eviction, and on the other, you are helping us or interacting with so many documents in terms of the industrial policy to allow us to set up a policy. And considering all this, my lord, in the last section, someone could directed that kindly take your instruction as to what the government wants to do actually. And this is a sort of instruction which the DC possibly cannot take. I pray, my lord, that you also will give us some time. We'll file an affidavit.
above that, there are some questions raised whether section 21 will be applicable, section 22 will be applicable, whether procedure prescribed under Ceiling Act is followed. All these questions are there in this report.
They are, but then these are raised. But otherwise, if your lordship goes to the report based on which it was done, possibly these are all technically taken. Otherwise, they admittedly they are in.
No, we are not expressing any opinion, but so far relating to deprivation of right of property, the procedure prescribed, you cannot say as a technical thing. I do not know in what circumstances, because there may be some issues that this procedure was not even required in the given facts of this case. Many things are there. So if you say you want to file an affidavit, this is when who is you are possessing?
I am deputy. But the reason for which no affidavit was filed is that against the refusal of interim order, they preferred a writ appeal. Writ appeal, in the beginning, there was an order of status quo, but the writ appeal remained pending.
Still now.
5 years.
Now what happened?
Now it has been disposed of. Of course, already it was disposed in 2018, I think.
Now what is the status quo to be maintained?
Status quo is being maintained. Now,
in writ appeal also?
No, writ appeal is disposed of with that observation. That status quo will be maintained.
Status quo. Initially, there is no interim order.
Initially,
so they preferred and writ appeal, status quo has been
yes,
granted.
Yes.
So now they are possessing. Let us decide this matter.
Yes, ma'am. Lordship will give us 4 weeks time, my lord. I want at a time so that we can bring, because of this, my lord, pairwise comment was not asked for. This one could directed that you take an instruction as to what the government wants to do.
This, we have written twice, two letters, pursuant to your lordship's last direction. No response is forthcoming, my lord.
Don't say we did before this court.
No, my lordship directed.
Then what will say that the additional advocate general has failed to obtain instruction. So let them be personally present here.
No, no, I'm not saying that. Letters were written, possibly.
If they are not responding,
No,
we
madam.
know how to, you may not know
Not because.
how to get instruction. We know how to get.
What I am indicating
We'll
is
record that and we'll call the.
I'm indicating something else. Not because they did not respond to our letter, because of the nature of instruction that we are asking for. One particular person will not be in a position to give that reply. That is possibly the difficulty.
No,
I
see,
pray, my
a
lord.
person has taken a decision
My lord.
to be a selling surplus land, this,
Yes.
that.
After
It must have some materials. These are the materials, whether on this basis
Yes.
this order could have been passed or not. What
Exactly.
more do you require?
Exactly.
That's all. Record of the proceeding we need. That's all.
Records meaning all communications they have already annexed here.
Lordship,
Otherwise,
this matter may be fixed for hearing. In the meantime, my learned friend may file affidavit of opposition or not.
You want
That should
to
be
issue a
discussed.
rule?
no,
Yes,
no,
by
no,
issuing
my
the
lord.
rule, Lordship. Because
It will
Lordship,
delay
after
further, my lord.
disposal of the writ appeal, Lordship,
My lord,
many the
lord,
orders were
may-
taken in 2023.
Okay,
Time
Mr.
was
D.
taken. Lordship.
Mojumdar, Learned Counsel for the Learned Additional Advocate General of Assam, submits that he may be granted further 4 weeks' time to file affidavit as a last chance.
my lord.
Full stop. Prayer is allowed inasmuch as an affidavit from the state authorities shall be required for appropriate determination, proper determination of this litigation. Full stop. List this matter on 21st of October 2024. Affidavit be filed, not 21st, 21st reopening,
Reopening.
immediate after 3-4 days.
Then 24th will be Thursday.
24th of October 2024. Affidavit be filed before the aforesaid date. List accordingly.
Item 4 and 5.
Wait, Mr. Lord.
Yes.
My lord, here, this land, my lord, is a selling surplus land. We are in possession from long time. It's
No,
starting from
they say that you have already been evicted and you are not landless. They are stand in the affidavit and you have not filed reply.
My lord, I have not filed reply. Your lordship will be pleased to take.
No,
the
Mr.
affidavit.
Sheikh, before going to the argument, let us summarize the issue. Let us not waste time. After 10 minutes, let us not adjourn this matter. They has taken a specific stand that these are the land selling surplus or whatsoever. You are illegally occupying this land. First stand.
Right.
Second stand is that somebody paid tozi or something, some what is called some fine, somebody has paid some fine also, and they take a specific stand showing in their affidavit that these people are not landless people, therefore there cannot be any settlement. Do you want to refute such stand, or you want to proceed with the argument on the basis of that uncontroverted fact? That's all. That is the question.
My lord,
Option is yours.
only one thing, my lord. I'll file reply.
No, give us the answer. Then we'll go to your merit. Do you want to file a response to this affidavit or not? That is all. If you say no, then we'll deal with this. If you say yes, then we'll adjourn at the end of it.
I will get.
Mr. Sheikh, Learned Counsel for the petitioner submits that. So that until and unless if you refute those and we are satisfied, we cannot give you any relief. Submits that he would like to file a reply to the affidavit in opposition filed by the Assistant Commissioner Gwalpara, Assistant Commissioner Gwalpara, full stop. Prayer is allowed. List this matter after vacation. List this matter.
Any date.
List this matter. After vacation, give a date. 23rd of October 2024. Both 4 and 5. Yes, you have been appointed an amicus. Yes, report, some reports are sought for.
Yes, so we have got
My
the,
humble prayer before, as per the provision of the act, this matter may be taken up in camera lordship. And one of my learned friend on the other side, Udas, she has requested, she has some inconvenience. She is in another, legs in another court. So it may be taken up at 2, if lordship is convinced at 2, as per section 34 of the act of Human Immunodeficiency Act. Lordship.
but in any view of the matter, we have it. It can be placed. Unless okay.
No,
Unless
the
and
other
until-
side also requests. some,
Other side means what?
Udas.
She is appearing for the government.
Yes.
Yes.
So in that she also have get.
I don't know whether I have been communicated by you as because I have my set of instruction.
You are representing?
Government, state government.
She is also.
Oh, okay. She told me yesterday, this is the reason I have submitted before this. If you have instruction.
So
What is that report?
if at all it has to be kept in camera, I don't know, but as regard the present status, we have been asked to file that SDMO. So they have been asked to give the presence report as regard the whereabout of the child. So it has been said that inquiry has been done. The child has been attending to one school, and headmaster of Bongsor Jatiya Das High School has been inquired.
These things are being revealed in the open court.
No, they cannot. There is a
This is the
bar.
reason I'm humbly praying that. as
No,
per
there
section
is a bar
34
to reveal all this.
Yes, lordship, school and identity.
That is identity you cannot disclose.
Yeah, no, school is name.
You are
of the
disclosing the
school,
school.
name
Do
of
not
the school,
see, give in a
lordship.
seal cover.
Its name of the school is
No, you
revealed.
give in a seal cover.
In fact, the previous order doesn't contain any such directive.
Do you require to say you everything that this is the mandate of law?
But
You are not supposed to know the law.
I am supposed to know,
Then-
but there was no.
And so you are, see, Mr.
I'm
Burua,
not
don't
mentioning-
argue all these
I'm
points.
not mentioning the.
There is a mandate of law.
Definitely.
Certain things, you follow it.
The identity has.
Don't
to-
argue that court has not directed us, so we are not aware. That cannot be. So what to be done today or some other day?
Since he's representing the governor, I don't have any issues. And also, health department also need to get certain instruction, lordship, as per the last order, lordship. DP Borough Learned Council appearing for the state shall receive instruction as to the further step taken in the matter after preliminary inquiry.
That is what I was. So why today no health department council is here in any of the matter? What is this? Wait for some time. See, we may take up today because we may be in the midst of some important hearing. In the
Yes,
second half, we have
yes,
fixed
yes,
this
yes,
matter for AG. Huh?
Yes.
Please, your lordship.
Mm.
Lordship, the matter has become infructuous.
Why? You have been settled with let?
Yes, lordship, the petitioners have been allotted the let.
Okay. It is submitted by you are Mr.
Yes, sir.
A. Sarania. On behalf of Mr. M. Sarania, Learned Council, that this matter has become infructuous as the grievance of the petitioner has been redressed by the state authorities. First stop. Accordingly, this writ petition stands closed being infructuous.
Hello, right.
My lord, when the writ petition was filed, my lord, the judgment of the division bench was not there. So, my lord, your lordship dispose of in pursuant to division bench judgment.
No, they say that
That my grievance was that, my lord, grazing land was de-reserved and it was settled with the others. I filed an application for settlement. Then
what is their instruction?
no affidavit, nothing has been.
Let us give a chance to have the instruction. Yes. Who is representing? Who is representing the circle of the deputy commissioner?
You can have after some time because the file is being retained from there.
Or after some time, after some days, my lord.
After some days, on the prayer of Mr. Borua, Learned State Council, matter stands adjourned and we list it after 2 weeks. You are still in possession.
My lord, the interim order was on 19/4/2017. Interim.
কি করলো? Be listed on when?
As per the court's convenience.
Give a date. 23rd of September 2024, not 23rd, this will take some time. Let it go after vacation. List this matter on. Interim order is there, let us go to
The interim order 19/4/17 will continue.
22nd of October 2024. In the meantime, the state respondent may obtain instruction as to the present status of possession of the petitioner, as well as whether it is correct that the land, VGR land has already been de-reserved and settlement has been made to many other similarly situated persons. Full stop. Present status. Okay, okay. That is the issue. He said that.
We have the status, but it is old one. It is 2017. So let's have it.
In this matter, I have no instructions since 2019 for my client, my lord. Otherwise, one report was submitted in 17/7/2019 before this honorable court that they have almost completed the investigation on our.
Close it.
Yes, my lord.
The present writ petition is filed alleging that the respondent or authorities has not properly investigated the matter. This is item number?
Completed the investigation after the lodging of the
item number?
2015. And we have
No,
filed
this is
writ petition
item
in
number 9.
2017.
এটা কি ফাইল দিলে? Item number 9 is something different. Diligent media.
This is
No,
diligent.
this is some different file.
9 is Diligent Media Corporation, my lord. WBC number 1180.
I recall it. I have seen this record. The present writ petition is filed. Alleging that though the it is the case of the petitioner that the petitioner had filed an Ezahar before Dispur police station on 7/8/2015, which was registered as Dispur PS case number 1644/2015 under section 420, 406, 467, 468 IPC. However, the investigation was not properly done. Full stop. Record reveals that record reveals that during the proceeding of this case, the officer in charge of Dispur police station has submitted a report to the extent that a report to the following effect. Order and page 9, pencil to pencil, full stop. In view of the aforesaid, in the considered opinion of this court, the petitioner should not have any grievance as regard the investigation. Accordingly, the present writ petition stands closed.
Obliged.
Should not have grievance at this stage after the aforesaid report. Accordingly, the present BK Singh, learned counsel for the petition. Okay.
Obliged, lord.
In this case, I pray for some accommodation. The petitioner, my lords, is admitted in the ICU. Nimcare, my lord. I just received the information. I have absolutely no instruction.
Okay, on the prayer of Mr. Ganguly, learned counsel for the petitioner, matter stands adjourned in as much as he submits that he could not complete his instruction and the petitioner is right now hospitalized. List this matter after puja vacation.
So there is an interim order.
Interim order pass earlier shall continue till the net days the list.
Item 12.
Anything survives?
Sir, Lordship, this matter has become infructuous.
Infructuous, that is it, sir. The learned counsel for the petitioner submits that the writ petition has become infructuous. Accordingly, the writ petition stands closed being infructuous. IL, if any, stands closed.
My lord, in this present writ petition, the impugned circular cum order issued by the respondent number 3 has been withdrawn by them since the writ petition stand infructuous.
Okay. The learned counsel for the petitioner submits that the impugned order dated order dated 3/1/2017 issued by managing director of Assam Seed Corporation Limited, whereby it is the learned counsel for the petitioner submits that the impugned order, the order which is under challenge before this court, has already been withdrawn. Therefore, nothing survives to be adjudicated in the present writ petition. Accordingly, writ petition stands closed, being infructuous.
Much obliged.
Item 16.
Fourteen, 15, adjourn. None appears for the petitioner on call. None did represent the petitioner on 16/8/2019 and 2/3/2022. Full stop. On 2/3/2022. Full stop. This court, in its order dated 2/3/2022, observed that no, not necessary. Full stop. Full stop. Not necessary. Full stop. Last line, huh? Okay. Accordingly, the present writ petition stands dismissed for non-prosecution.
Item 18 and 19.
Yes.
Can you pass over the record?
Item 20.
Yes. Not paid the awarded amount.
Okay.
What is the remedy? Writ court. Any statutory provision. When award is passed, this is an award. Is that it? Award by arbitrator. Now, how it is to be execution? In case of other act, it is the corresponding court, civil court. Now, any provision under this act?
I'll go, my lord.
And who is the respond? Yes, what is your stand?
Lordship, I'm for respondent number 1, NHI, but the road concerned is not constructed by NHI. So on the last occasion, he was supposed to file
Who constructed the road?
NHI DCL.
NHI DCL is a party.
He was supposed to file an application impleading NHI DCL.
Who will implead and look into it.
But it has not been done so far.
Okay, Mr. R. Ali, learned counsel for the petitioner, submits that he may be granted 2 weeks further time to file an impleadment petition to implead NHIDCL as party respondent. Prayer is allowed. List after 4 weeks.
Lordship, I'm for respondent number 1.
Mr.
A. Borua, on behalf of Mr. C. Borua.
Mr.
SCNH.
A. Borua,
On behalf of Mr. C.
on behalf of Mr. C. Borua is present
SCNH.
for NHI.
NHAI.
Obliged.
Obliged, Lordship.
Yes, Mr. Das.
On the last date, your lordship directed the both the matters were connected. One is in Malad where the order is given for demolition. The other is demolition because Malad the petitioner is admittedly Malad in possession of.
Petitioner is admittedly possessing a land of a different person.
No,
but
no, same person because the
same owner, and that sale process is underway.
And the sale process has been Malad, and this process has been initiated by his neighbor, Malad, who is an official of the JDA.
You are enjoying a stay.
We are enjoying it.
Enjoy it. Though Mr. B.D. Das is present, none appears for the respondents. Accordingly,
Circle officer has not filed a.
no pleadings is also not complete. Accordingly, list this matter after 6 weeks on a date to be fixed by registry. Interim order.
Circle officer may be produced.
Let us see. In the meantime, interim order pass earlier shall continue until further orders.
It is already there. State.
Further order is there?
It is already state.
Okay.
Now, only my prayer is that they should produce the circle officer record. Circle officer can.
In the meantime, the circle officer shall file its affidavit
That is already
in as much as
That is already
there.
They have to produce the record.
Any urgency on your part?
There I am.
Let us see. You are having the house, you have purchased 2 plots of land, building is
The old
constructed.
man is facing problems
Yes.
from his neighbor. Man.
And let him answer, let us not talk. Namima, Bharat.
Okay, in this matter, I need some time to get instruction.
You have heard a case,
Dismissal.
Mr.
C. Sharma.
C. Sharma, learned standing counsel for the Dismissal press foreign is granted
3 weeks time.
3 weeks time, 4 weeks time to file affidavit in notes operation. List accordingly. Any interim order?
I think no lordship.
I do not think. Okay.
Senior is saying.
The present petition is filed assailing an order, primarily assailing an order dated 25/4/2022, passed by the additional district judge number 1, Kamrup M, in Miss Appeal number 13 of 2015, preferred by the petitioner under section 9 of the Public Premises within bracket Eviction and Unauthorized Occupants Act 1971. Full stop. This court is of the prima facie view, subject to further deliberation that may be further argument that may be advanced, that there is no perversity as such in the order passed by the learned additional district judge number 1. First, at this stage, Mr. Mojumdar, learned senior counsel, submits that he may be granted 4 weeks time to go through the record and address this court. Place this matter on. Give it at 24th of October.
Lordship has mentioned Miss Appeal 13, Miss Appeal 19.
19 of
19. Miss Appeal 19 of
50.
So,
October. Mr. Das, we'll take your matter after completing the list.
At 2 o'clock,
Hmm.
the matter has been fixed by all the court yesterday itself.
But it may not reach 2 also. Only 5, 6 matters are there. You can start it.
In
Let
that
us see.
case, my lord, my humble prayer, learned
No, AG, let the AG come.
He is on lakes in court number
Okay, we'll
20 for
see.
some.
Okay, next.
2 o'clock, I have some difficulty.
Okay, you have a talk with AG.
In that case, my lordship may fix on Monday.
No, we are not saying anything. Like you have the instruction from AG. Let
Yes, I
it
have been
be
instructed, my lord. He is lakes on court. Solely, yes, sir.
Okay, next case.
Koran, solely, yes.
My lord, I have challenged, my lord, this eviction notice, my lord. It's page 48. Because, my lord, since 2004, my lord, I have purchased a plot of land and my lord reside there on my lord. And
You
private-
reside there, but why you construct a gate in the government?
My lord, and my lord, I am not my lord, my lord, accepting their, my lord, content that I am in the government land, my lord. And my lord, since 2004, my lord, and a private respondent, my lord, came in 2020. And my lord, they lodged a complaint before the circle officer. That copy also not furnished to my lord, this
So
petitioner.
they will furnish, you give a reply, you will be heard and decided.
Otherwise, he was served on 2 occasions, Lordship.
No,
3 occasions.
That complaint lodged before the circle officer, not sir.
No, basically impugn order is page 48.
Yes.
Is not it?
Yes.
In terms of page 48, it is not a notice. He was asked to remove. Is not it? Mr. Burua?
Yes, yes.
So
yes.
what we are saying is that you give him a notice, let him reply, you hear him and dispose it of. In terms of Salahuddin. Page 48 is the impugn notice.
The issued by circle officer, my lord, under rule 18(2). And jurisdiction of circle officer is not also, my lord, to issue, my lord. It is, my lord, confined to DC and additional DC and LTO,
Why?
not circle officer.
Why?
Because, my lord, he has not been entrusted the power of, my lord.
No.
Under which provision?
My lord, the definition, my lord, I will show next date, my lord.
No, why next day? I have seen it's now become a practice. A question is put, then the lawyer will take that I will do my homework tomorrow, not today. This is, I think, the third case. So as that circle officer is not having power.
And in such case, my lord,
No,
rule
forget about such case. You go to the settlement rules, rule 18.3 of the settlement rules, 18.2, and the land and revenue regulation, who will have to issue, who is the where, why are you making a statement the circle officer is not having a power? Tell us that.
I saw, my lord, I saw.
So we'll vacate the stay. You will show whenever you want, we'll vacate the stay.
My lord, another prayer I have, my lord, is
No, first confine to this, then we'll go to the other prayer.
at 2, my lord.
At 2, not possible. List this matter on Tuesday. On the prayer of the learned counsel for the petitioner, list this matter on Tuesday given. 10-9.
Item 25.
My lord, do I mention, my lord, but IA has not come, my lord.
Okay,
Let the matter come other days, my lord.
Other day.
You can-
It is submitted by the submitted that an IA has been filed for implement of new respondents.
New respondents.
Same is not on record. Register to verify and list the IA along with this petition. When?
Next week, man.
Give a date. 13th.
Item 26.
Well, there are 2 prayers, my lord. If your lordship see, my lord, this prayer 1 has been settled, my lord, at page 25, my lord. This, there was
Advance
a
tax refund.
refund, my lord, that prayer 41, my
Pace,
lord.
pace.
It is regarding 41 crore 48 lakh.
Pace, pace.
Page 25, my lord.
Pace
Page 25,
25.
my lord. Prayer 1. It was that of a demand of rupees 41 crore 48.
So prayer 1 is
Settled, my lord.
redress, settled.
Only
Then
thing, my lord, remained prayer 2, that there was a refund for the assessment year 22-23. My lord, your lordship may dispose of the matter, directing them to consider it and pass an appropriate order.
Section, the grievances of the petition have been addressed and matter has been closed. And all the benefits has been granted to the petitioner. These are my instruction, Lordship. And moreover, Lordship, the petitioner appeared before the authorities and he said that I am satisfied with the, and he's going, he said that he will instruct his counsel to withdraw the case. These are the documents provided by the authorities, Lordship. Then, Extra premium.
What you say on that?
My instruction is this, my lord, that so far main, this 41 crore is concerned, yes, I'm giving it up, my lord, because it's been settled. Only for 22-23, my lord, second prayer. That, my lord, observation may be made and disposed of, my lord. Let them pass an appropriate order in this regard. If it is.
No, they say that we have already passed an order.
No,
Given copy.
I'll give
main demand, my lord, 41 crores.
And what about 243?
243 is for the assessment year 22-23, my lord. Only for that, my lord, your lordship may made an observation and disposed of the matter.
Heard, Mr. Sahayola, learned senior counsel, assisted by
K. Sharma.
K. Sharma. Also heard Mr. S.C. Kyle, learned standing counsel for tax department. Income tax department. Full stop. The present repetition was filed assailing an impugned demand notice dated 27/2023, whereby a demand of tax to the tune of rupees 41,48,60,940 along with was raised. Full stop. It is submitted that it has been
They have adjusted, my lord, the earlier.
such demand has in the meantime been settled by the petitioner and the income tax department by making some adjustment. Full stop. The second prayer of the writ petitioner was to issue a direction to grant appropriate refund for the assessment year 2022-2023 to the tune of rupees 243,50,280. Mr. Sayola, learned senior counsel, submits that matter may be relegated to the tax authorities for consideration of such prayer. Full stop. However, Mr. Kyle submits that as per his instruction, the entire dispute between the parties has been resolved. Be that as it may, in the backdrop of the submission made herein above, nothing survives to be adjudicated in the present representative petition. However, the petitioner shall be at liberty to approach the competent tax authority, even if according to him the grievance under prayer number 2 has not been redressed. Full stop. In the event such application is filed, same may be considered and disposed of by the competent income tax authority. Full stop. Accordingly, writ petition stands closed.
Passing a return order, my lord.
Huh?
Passing a return order.
That is what consider and pass again.
Item 27. Due to electrocution, my lord.
Yes, state affidavit.
Lordship, affidavit should come from.
Yes, state electrical inspector. Inquiry report.
My affidavit file for me. From our report, Lordship, so for our instruction, Lordship.
No. First of all, there's an independent authority who will do the, because you are a party to the dispute. We want a third party in terms of the section 161, I think. Yes.
Yes, Lordship.
Inquiry conclude.
We are yet to file our affidavit.
Okay. Learned State Council representing respondent number
4.
Press for and is granted 2 weeks time to file affidavit to bring on record the report. Inquiry report conducted under section 161 or 162?
161.
Huh?
161.
Section 161 of the Electricity Act 2003, isn't it? I forgot 61 or 161.
161.
161 of the Electricity Act 2003. Yes, next case.
161.
161.
May it please your lordship. My lord, petitioner husband had a life prayer price.
Yes.
My lord.
Affidavit. Are you still running the show? It is given to whom?
given to my husband, my lord, but he was.
No, no,
expired.
husband died.
Yes.
Now what is the status?
It was amalgamated to another sub, my lord.
Who is representing? Yes, who is representing this department? Food and Civil Supplies.
Lordship, I am fair.
See, an important issue here. A person is having a license
Lordship.
of fair pressure. He suddenly dies. And you say that it will go to some third party. Now, family, okay, you might have some law. We do not know. You might, and the license condition may be such that it is not transferable anything.
Yes.
But see a situation, here is a case, her husband died. And the next day morning, she is having no income because her license is amalgamated to a third party. You are a state instrumentality.
Yes,
You want to
he
know?
has to apply phrase, Lordship, in this case.
File an affidavit.
Lordship.
What is the procedure?
Because we have to tag that beneficiaries to another fair price shop because otherwise that beneficiary will be suffered.
No, that we understand.
Yes, yes.
But therefore, you have a satisfaction that this business cannot be continued by her. Is that it? So you have the satisfaction that she cannot continue with this, though a license can be transferred in her name, but since you will immediately not allow her, but to give it to some third party. File an affidavit.
Yes, sir.
When?
Lordship. 3 weeks, Lordship.
What 3 weeks? This is 2013 pending from December.
23.
1 year is, I think, not a great big period, no? See her predicament. She is raising a question of livelihood. We'll of course consider because expertise will be, many things are there. We cannot say that, but you will have to address by an affidavit. Mr. Burwa learned the State Council press for and is granted 2 weeks time to file an affidavit in as much as file an affidavit in as much as this matter is pending since 13/12/2023 and no affidavit has been filed. List this matter on before vacation. No. Within this month. 26th.
26th.
Item 29 and 30.
We thought that we'll take up this matter, almost list 4 or 5 matters are there. So we'll finish it up this. He is saying that the 2 he is having a huh? That's why we fixed this matter today.
In that case, let the matter be taken up next Thursday, Lordship. On
Thursday is a difficult day. In this court, hearing days we sit up to 5:15 because all hearing matters. Now miscellaneous days, all these more short matters. So we have time. By 1 hour, list will be over. Second half is almost free.
Lordship fix this matter on Friday.
Friday next.
And Friday next, and it will be.
Friday is what will be the date?
12 o'clock or
13 Friday we can take it up.
13.
Okay.
Because my friend has a matter at 2 o'clock. That's why I am not objective. At 2 o'clock.
I just.
And he got lot of fetching on the other. So he have to return it.
Where is the guarantee that on next Friday he will not have a matter fixed? at
That
2?
will have, but today he was a receiving and he received lot in his absence.
Okay. As agreed to by the learned senior counsel for the parties, list this matter on Friday next. 13.
I do not want to give him double facing here also.
13?
He did not.
We have not seen who will go where on 13th.
Interim will continue till then.
Interim order, passer shall continue till then. That's why we fixed this method today. I had the idea that we'll finish it.
Even I am ready.
I was also, that's why I thought I'll start the case.
No, we'll not do it half-hearted. I do not think it will take more than a half.
No, it will not take much time. Not much. Proposition of law is that.
Facts are more or less recorded in different orders.
Facts only two cows,
But
where
my-
they will stay.
Two cows.
Two cows where they will.
My homework is, but my homework is gone.
Is gone.
Yes. Yes, next.
Deeply.
Yes.
Sir, regarding land acquisition by the National Highway Authority, we have not partial land, but these are, there is some mandir and zirat. They have not been surveyed. We have earlier, I approved this honorable court, and the honorable court passed order, annexure 6, page 23, you will kindly see. Page 23 of my repetition.
See, in view of the affidavit stand taken at page 35,
Yes.
can we decide all this? How will you decide that no, this is not right of way? This is a patta land, it is not registered in. Yes, Mr. Rosid, tell us. Go to the proper court. No, we are open. If you can say that this is a read court can decide that this mandir situated and this area where I am claiming land is undisputedly a patta land. And this is the patta, this is.
I admit that is not partial.
If not patta land, they say this is under.
Do
you say-
that value may be given, that is our man.
Why?
Other person they are getting only I am single out. What is my wrong?
We do not know. You
That
show
is
us the road, right, that even if you construct a mandir in the right of way, you are entitled for zirat. So as the law, provision of the act. We are here to pass orders on the basis of your right. Where is your right? Tell us, we will pass this order in the admitted provision.
And that my lord, kindly see that.
Yes.
Actually, 3. The National Highway Act, my lord.
Yes, read it. Which provision?
No cover that 3D.
But mind it, this is a right of way registered in the name of NHIDCL.
That what?
Huh?
That what is the right of existing way?
It is not that some other land, government land, Exonia land, you are there, your house is constructed. Of course, you will get the zirat. No doubt about it. But it is admittedly a land belongs to National Highways, right of way, and you have constructed a mandir there. Now you want the price of the mandir, zirat. So as your right, we are right now asking them to.
To approve the approved code.
Approve whom?
Approved code.
If an appellate heard Mr. Rosid, learned counsel for the petitioner. The claim of the petitioner is that he is residing on a plot of land. Claiming. The present petition is filed claiming zirat compensation. Zirat compensation compensation against mandir and other properties constructed over a plot of land under DAG number 363 of Agia Part 2 Revenue Village. Full stop. A specific stand has been taken by the revenue authority. It is filed by whom? Respondent, who is respondent number 2? An affidavit has been filed by the district collector.
He is called Kala now.
Competent authority. A specific affidavit has been filed by the Kala. Taking a specific stand that an inquiry has been made as regards claim of Jirat compensation by the petitioner, and it was found that the structure, mandir belonging to the petitioner was constructed over Dag number 363 of Agia Part 2 Revenue Village, falls within the existing right of way of 21 meters within bracket required for current work, and is recorded in Sita copy as NH road, that is land acquired earlier for National Highway 37 within bracket old National Highway 37. Full stop. In the backdrop of aforesaid stand, Mr. Rosid submits that no. In the aforesaid in the backdrop of aforesaid stand, Mr. Rosid submits that as the disputes now revolve, as there are some disputed questions, therefore he may be granted, he may be allowed to withdraw the present writ petition and to approach appropriate and competent court to agitate his grievance as regards his right of Jirat over the aforesaid plot of land. Full stop. In view of the aforesaid, writ petition stands closed with a liberty as placed for him. That's all.
I am appearing for
I'll just write down the names.
May please, Lordship.
What
This
is this?
matter, Lordship, the
Who are the other side?
other side has, in spite of service of notices, they have not appeared.
Not appeared. What is this case?
Case is this, Lordship, there are three numbers of the petitioner. Number one is the grandmother of the petitioner, number 3, and number 2 is the daughter-in-law of the petitioner, number 1, and number 3 is the son of the petitioner, number 2, Lordship. And the husband of the petitioner number 2, Lordship, he has constructed RCC building at Bonda and let out the first floor to the SBI, Lordship. And SBI is depositing the rent in the court, but all of a sudden, Lordship, it has put the account on hold, Lordship, due to some objection raised by the respondent number 3, Lordship. Only my prayer is that the SBI may be directed to allow the transaction. We petitioner do not have any source of
SB
income.
is respondent number?
Respondent number.
Respondent number 1.
1 is the
and
extent.
2. Third, Mr. S.P. Roy, Learned Counsel for the just we are not disposing of, we are asking the State Bank to appear here.
This have been served, Lordship. They had not paid.
But we'll give a chance. Can we pass an order like that?
Your Lordship, please to peruse the order dated, Lordship, 12/6/24, where notices were served. Thereafter, your Lordship gave them 2 chances, 14/6/24 and 21st of August. Lordship, the petitioner do not have any source of income.
No, that we are doing. Just wait for a minute.
Petitioner number 1 and 2, they are widows, and petitioner number 3 is unemployed youth. Huge amount is lying, Lordship, above 60 lakhs.
State people. From the perusal of the pleadings made in this writ petition, State Bank of India, that is respondent number 1 and respondent number 2, are vital for determination of the present writ petition. Though service in respect of
All the respondent completely.
a service upon the respondents has duly been effected. However, none appears for the respondents. Full stop. It is unfortunate to note that a nationalized bank is not responding to the notices issued by this court. Full stop. Therefore, this court is to take adverse opinion against the respondent bank, more particularly against the respondent number 2, and this court may also pass order for appropriate action against the concerned branch manager of the bank. However, before passing such order, this court thinks it fit to serve notice once again upon these 2 respondents. Accordingly, registry is to serve a notice upon respondent number 2 through the office of the district judge Kamrup Metro through a special messenger, along with a copy of the writ petition and the order passed today, intimating that the branch manager of State Bank of India Bonda Sariali branch is required to personally present before this court on the next date fix. Full stop. Next date fix. We'll do it not through this, comma. Such notice will change it. Such notice along with the writ petition be first what will be next Friday is 13th. Next Monday, 16th of September 2024.
Item 33. May I please, Your Lordship? This case, Your Lordship, non-payment of bill, Your Lordship. In fact, Your Lordship, the ground on which they have not paid us the amount due to us, Your Lordship, that has been considered by this honorable court. Your Lordship,
Let me find my affidavit, my lord.
Your Lordship, kindly see page 37. This is the only ground, Your Lordship. They are not. And from GMC, Your Lordship, they need so much time. And I have in requirement of money, Your Lordship. Your Lordship will kindly see page 37, Your Lordship. During the pendency of this writ petition, respondent number 1 to 5 had filed a counter inter alia contending that dumpers of higher capacity were available in the market on higher at ₹6,000 per day. Therefore, the rate claimed by the petitioner was exorbitant, Your Lordship. Now, they themselves, Your Lordship, by issuing work order, has fixed that rate, Your Lordship. Now, court held that they cannot do this, Your Lordship, and directed the other contractors to pay. Now, since I am not party to that proceeding, Your Lordship, they are not paying us, Your Lordship. What kind of, Your Lordship, act is this, Your Lordship? And we have brought this order to their notice by page 39 representation, Your Lordship. Exactly the same case, Your Lordship.
What is your instruction?
Let me find my affidavit. That instruction has been prepared. I will get in day or two, my lord.
What is your instruction?
The instruction I have not received it, my lord. They are preparing it, man. I will within day or two I will get it, my lord.
Okay. List this on the prayer of Mr. S. Bora, learned counsel for the respondent number 1 to 4. List this matter on. Give a date next Friday.
Not next Friday. After 10 days, my lord.
You have granted 2 weeks time on August.
My lord,
on next Wednesday.
Yes.
Next,
Next Wednesday.
11th.
Lost.
Not this way. Not 18th. 18th of September 2024. However, it is made clear that if no affidavit is filed by the next date fixed, the matter shall proceed. the writ petition shall be decided on the materials available on record.
Item 34.
30,
Item 34.
34. Yes.
Nath is on late some other code perhaps. He told me, Mr. Nath.
Let him hear him. Because we have just, otherwise our first part is clear, we have raised some issue, let us understand what to say. Whatever came to mind of this court, we have expressed, you have answered. Most of the,
On the last occasion, Lordship.
we have raised some issues.
Lordship raised some
So
queries
we'll
from-
just wait, let him, what is his case?
No.
Your Lordship, wait please, Your Lordship. Rather than the factual aspect, I would like to straightway go into the point of law raised by this honorable court. The first point which I want to address, basically I'll address on few points.
Now, first you address what is your case.
Yes,
We'll
Your
go to law. Law we have entered into because this came into mind. But what is your case? A pleaded case.
Yes, Your Lordship. My
What is
pleaded-
your pleaded case?
my
Because
plead-
in a contractual matter, we may deliberate many things, but we may not go beyond your
Exactly,
pleading.
Exactly, Your Lordship. Page
So what
50
is your case basically?
Your Lordship, basically the case is at page 55, they have sought for a document that is EPF up-to-date payment challenge along with up-to-date labor license and ESIs.
Case?
Page 55.
Mr. Sinha, wait for some time. There are 3 leftover matters. We'll free others.
Pending item 51.
Yeah, what is this?
Regarding the service of response number 5, my lord, proper address was not there, my lord. We had taken dusty service, my lord, but it could not be traced out, my lord.
You serve it.
My lord, the problem is that because the concerned contractor, he is not available in the office or in the college. Some personnel are working there.
Suppose you want to send a notice to him, what will you do? Or is there any contractor exist at all?
No,
We'll doubt that.
Contractor is
If
there.
your employer says that we do not know whereabouts.
No, my lord, that I am not saying. I am saying that for service of notice, whether we can contact the contractor for that purpose, because it is because some person is there on his behalf, on behalf of the
So
contractor.
I think so we'll record it. They don't have any control over the contractor.
No, my lord, that is not.
That is, if court says that you serve a copy, you say that we do not know where his laborers are there, he is not there. This is your case.
No, I am saying that probably, my lord.
Not
I am
probably, you
sure.
must be clear. See, a contract is challenged, there is no address of him, according to have filed an oath on affidavit, they have filed it. That we tried it, we went there, there is nobody.
Yes, my lord.
Now, if you also say that there is nobody,
No, my lord.
then
I am
we'll
not saying-
presume that this contract is a bogus contract.
I am not saying that there is nobody. I am saying that the contractor may not come to the office, my lord, very often.
So
my lord.
therefore, you don't have any control over your contractor. You don't have his phone number.
Yes.
You know nothing about your contractor.
That way it can be tried, my lord.
Isn't it? It's
Yes.
your contractor. What are you saying that we do not know who is he or how we cannot serve?
The purpose of serving the notice.
Why not? Why not?
I-
Suppose you want to terminate the contract tomorrow.
Yes, my lord. We can send.
So you are helpless.
No, my lord.
Then
We can
don't
send
make
a
this kind of submissions. Then it creates itself a doubt.
My lord, the main problem is that I don't want to take the burden of service of the notice on the private.
Okay,
That is
okay.
the-
We are
because
asking.
but my lord,
We are asking the.
if your lordship.
We are
may not-
asking the.
If your lordship.
If you do not want to take,
No,
we
no, my
give
lord.
the
If you-
burden to the
No, no,
officer.
my lord. If
Let
your-
him come and say that this is his address.
No, my lord. Your lordship, if directs, then I will try to.
See, Mr.
Yes, my lord. I will try to. Sir.
These are the issues
Yes, my lord. I will try to.
where where there should not be any debate.
Yes, my lord, yes, my lord.
Moment we express our view, the department
Yes,
and
my
come and say, yes, why not? We do
Yes,
it
my lord, yes,
for
my lord.
early dispensation of justice.
Yes, my lord, I will do.
We know how to get it done.
Yes, my lord.
We expect that as a employer, you will say, okay, why this litigation should be delayed for want of service? We'll help this court.
Yes, my lord.
This is the state litigant. If you take this stand, we know how to get it done.
Yes, my lord.
The notice upon respondent number
Respondent number 5.
5
Yes, sir.
could not be served as the petitioner could not find out him as stated in the dusty affidavit. Full stop. A specific stand has been taken that the office address given in the office address declared by the respondent number 5 is also office could not also be fined. In the aforesaid backdrop, this court is of the view that to shorten the stage of service, the principal, where is the respondent number?
2, my lord, is the principal.
Huh?
2.
The respondent number 2, that is principal, comes chairman HMS Assam Medical College Dibrugarh, Assam, shall be best person, best authority to serve a notice upon the respondent number 2, the respondent number 5, inasmuch as it is an admitted position that pursuant to the impugned tender notice, the work has been awarded in favor of the respondent number 5 by the respondent number 2. So accordingly, it is provided that the petitioner shall furnish a copy of this order along with a copy of the writ petition complete in all respect upon the learned standing council for the health and family welfare department, Mr. Bora, Mr. Bora, learned standing council family welfare and health department, and the office of the learned standing council shall thereafter forward the same to the principal cum chairman to the respondent number 2, and the respondent number 2 shall serve such copy upon respondent number 5 and thereafter file an affidavit effecting such service. The learned counsel for the petitioner serves such copy upon the learned standing council within a period of within a period of 5 days from today. Full stop. The notice should be routed through the registry of this office. Then only. Why?
Yes,
how
sir.
can he?
Yes, my lord. Oblige, my lord.
Pending item 6.
I have received, madam.
We'll take it on Monday.
Monday.
I'll go through this record in the chamber and we'll have it in camera at 2 in our chamber.
Some info, some time has been prayed for to give
Okay, you want some time.
but the authority wants some time.
Okay, then to no point keeping in camera.
Next week, Friday or my lord.
Okay. Pursuant to this court's order dated 7/8/2024.
Lordship.
No,
Lordship,
you have
place on record, my lord, so that my lord.
received the instruction,
Instruction received, my lord.
not the report.
Report, in fact, lordship can be treated as report also because some inquiry was made.
Pursuant to this court orders dated 7/8/2024, though an inquiry has been made and a preliminary status report has been submitted. However, MSU learned counsel submits that she may be granted some time
My lord, 10 days time.
10 days time
Hmm.
to file a comprehensive report as required under this court's order dated 7/8/2024.
My lord.
Full stop. Okay. Prayer is allowed. list this matter on.
12,
12.
12 will be too short, but still.
Okay, we give that, we
In fact, the law also says that it has to be expedited.
12
Section
12
34,
12
subclause
because
2
today
got
when I talked to the ADC,
12.
Malad,
List this
she's
matter
also
on
taking
12.
Yes,
12.
Lordship.
12. However, considering the provision of
Section 34, subclause 2.
Section-
I'll just read out the procedure.
section 24 or 34,
It is.
subclause 2 of
The Human Immunodeficiency Act of 2017.
Human Immunodeficiency Act 2017. And also considering that the issue involves of a minor under the aforesaid provision, let this matter,
Legal proceeding concerning or relating to so and so.
let this matter,
The court
be-
shall take up
matter-
and
let
dispose
this
the
matter
proceeding on
be
priority
taken
basis.
in camera on the next date fixed.
12.
12.
Lordship. And report may be, Lordship may be.
No, I think you take it back properly, Khalid. But you, all these matters, privacy is very important.
Lordship,
So
Lordship, I
you,
understand, ma'am.
you
Yeah, my lord. I'll ask them to send it
say
in an
this
envelope.
envelope seal cover.
Seal, Lordship.
They may give you the forwarding report and summarize you, but report should be.
Because they could not trace the boy.
Okay.
Now they are staying in the metro area. But
We'll see next date.
but-
Let us see.
my lord,
Details are in the, since it's in camera, I don't want the men's camera is there, so I
We'll-
can reveal the states because I also closely work with the AIDS Control Society, so
Okay.
I have few details, so that I cannot reveal right now.
No,
This
so
is-
therefore,
Fine.
we will have it in camera
my
and,
lord, my lord.
and on from that onwards, we'll proceed in camera.
And the camera.
Yes.
Lordship,
Yes.
deeply obliged.
Yes.
Deeply obliged.
Deeply.
34.
Yes, sir.
May it please, Your Lordship. Your Lordship will kindly turn to page 55 of the writ petition. That is qualification
You can-
2A, Roman small 3. EPF with up-to-date challan.
Which paragraph?
Page 55.
Page
Your Lord-
55,
Clause 3.
clause 2A, Roman small 3.
May I read, Your Lordship?
Yes.
EPF with up-to-date payment challan along with up-to-date.
Clause 54. Qualification criteria.
Yes, 2. It starts at page 54, but the relevant provision is at page 55.
Clause 2, GST registration, EPF.
EPF with up-to-date payment challan along with up-to-date labor license and ESIC.
Hmm.
The word is up-to-date labor license.
Hmm.
Now, Your Lordship, I submitted my bid.
Hmm.
Now, the rejection order is at page 307.
Here, no other clause is important except this clause.
Yes, Your Lordship.
And where is that clause, that historical document?
Yes, Your Lordship. It is at page 50.
Let us first see the important clauses. Then we'll go to the facts.
Yes, Your Lordship.
Yes, 50, is not it?
Yes, Your Lordship. .2. Notification to law. The bid evaluation committee may request the bidder to submit necessary information or documents which are historical in nature and audited statements of accounts, tax clearance certificate, PAN, etc.
Just a minute. Historically nature. Sharpen corridor. Good. Yes.
Now, if your lordships kindly come to page 307, that is the rejection, your lordship. May I read, your lordship? Before that,
Just a minute, just a minute.
I'm sorry, your lordship, I'm sorry.
Right. Thus,
My lord,
read the whole 30,
30?
clause 30.
Yes. What?
Immaterial non-conformities in bid.
Yes. The
Those
bid
who are no, those who are immaterial
immaterial non-conformities in the
bid, that can be rectified. Okay?
The bid-
Immaterial comes with this certificate. And admittedly, this certificate is treated to be immaterial and rectification was allowed.
Lord, perhaps that is not the whole, but immaterial, I think, which will not change the structure of the bid.
No, just read it.
Yes.
The bid evaluation committee may waive, because he has not read that. Waive non-conformities in the bid that do not constitute material deviation, reservation or omission
and deem the bid to be
responsive. So according to them, they have allowed the rectification of a document in exercise of this power, isn't it?
Yes.
That's
So
it.
no material deviation.
This is not no material. This is not a material deviation.
Material deviation, because nobody was allowed to give any fresh thing which will change the entire structure
Understand.
of the.
But admittedly, labor certificate, EPF, etc., not material deviation in terms of this.
That your lordship has to.
No, what?
Because I cannot give a meaning to this,
This is clear. Nobody should give a meaning. This meaning along with the action gives the clarity.
Lordship will
Though
kindly
affidavit
appreciate
is not
that.
clear.
Lordship will, because perhaps your lordship will also.
Okay, we'll come back at 2. Just these are running things.
Yes.
This is not the decision.
No,
Don't think that what I express is me. Don't
These
take
are
it.
queries, my lord. Lordship is having queries in mind, expressing before us,
Yes.
so that we.
Otherwise, it difficult. What should be your answer?
This is the nicest thing, my
Yes,
lord.
that is what.
Yes.
At 2. Maybe 2.5. Because no other methods are there. Koiba means method 2, that I'll take at a 2.5. Just tell them. Koiba method it will take 5 minutes. I think that will be though virtual that Mr. Medhi will he's here. So ask him to be wait for 5 minutes.
this officer's involvement.
Yes, 50,000 cost,
Your lordship, since the acquisition amount has been paid,
huh?
your lordship, since the acquisition amount has been paid, we leave it at this.
Acquisition emulsion has been deposited,
Yes,
so
sir.
we'll dispense with the cost now.
Yes, your lordship, we have no issues with that.
Okay. Heard Mr. S.K. Medhi, learned counsel for the petitioner. Also heard the learned counsel for the respondents. This is review. Where is the review petition?
Order dated 10/3/2023.
First of all, the present review petition was filed seeking review of which order?
10, page number 191.
191.
91.
Seeking review of order dated
10/3/2022.
10/3/2022 passed in WPC 86 of 2020. Full stop. It is submitted by Mr. Medhi, learned counsel for the petitioner, that the land acquisition compensation in question has already been deposited before the
My lord, address to the deputy commissioner, my lord.
before the deputy commissioner, district Dimapur, in the bank account of through State Bank of India cash management product fund transfer. Full stop. Such fact has not been disputed. In view of the aforesaid, the contempt petition file alleging non-compliance of this court's order dated 10/3/2022 passed in WPC 86 of 2020 has also been closed. Full stop. Therefore, in the aforesaid background, Mr. Medhi submits that as the order has already been complied with, this court may consider recalling the order of cost imposed upon the respondent number 3, that is Mrs. Annie Peria.
On page 2, my lord.
No, sorry, respondent number, কি করলো? Order of cost imposed under the order dated 10/3/2022 to the tune of rupees 50,000. Full stop. The learned counsel for the respondent. You are for the
Yes, your lordship, for respondent 3.
respondent. No objection.
No objections, your lordship.
Petition. The learned counsel for the respondent number 3 on instruction submits that she has no objection if the cost is dispensed with, for the reason that the land acquisition compensation has already been deposited. Considering the above, this court is of the view that while closing this review petition without recalling the earlier order dated 10/3/2022, however, the cost of rupees 50,000 imposed is recalled. Accordingly, the review petition stands closed. In view of the order passed in the review petition, IA stands closed.
Much obliged.
Yes.
May I please, your lordship? Your lordship, in the main writ petition, your lordship, one order is there 4/8/20. One order is there, your lordship, 4/8/2023, dated, your lordship. Where, your lordship, one order has been reflected that the recourse of to file application, substitution application, condonation delay, and for setting aside amendment proceeding can be taken, your lordship. So I have preferred the
Okay, fine, that's fine. Now you have to suppose
merit,
this
your lordship.
process.
Lordship.
What are the provisions?
Lordship may kindly come to page number 48, your lordship.
Yes.
This was a RTI reply, your lordship. And in a reply, your lordship, the municipality board, your lordship, who has acted as a party as a respondent, your lordship.
What is your grievance?
Your lordship, I'm coming, lordship. The thing is that 171 of the Assam Municipality Act, your lordship.
What
As
it says?
per that, your lordship, may I read the provision, your lordship? No person shall erect, materially alter or re-erect, commence or erect, materially alter or re-erect any building without sanction of the board, your lordship.
Okay, fine.
Now the respondents
Have materially done it, so they have done an commodity construction without authority of law. So their building is liable to be demolished. Okay, that is fine.
Again, 177 of
Yes.
Yes, lordship. Now, lordship, should a building be begun, materially altered or erected without sanction as required by section 171(1), your lordship, the board may by notice to the delivered within a reasonable time require the building to be altered or demolished as it may deem necessary within the scope of 30 days from the date of service of such notice, your
Okay,
lordship.
fine.
So that is my plea, your lordship, before the municipality board, your lordship, by a representation, your
Okay,
lordship.
that we understand.
Lordship.
But there is already a dispute, civil dispute between you and him. In that background, we are not passing this order at your behest. We will say that municipality will be at liberty to act as per law.
But with due respect, your lordship, with
Yes.
due respect, your lordship, on frequent occasion, your lordship, we have approached the municipality board, your lordship.
No, we understand.
Lordship.
Municipality board has not acted. Maybe we do not know. We'll give them a liberty. Admittedly, there is a dispute between you and them. What is the dispute? Tell us first then. What?
Recovery of the land, your lordship.
According to you, that they have encroached your land and constructed this building.
Lordship.
You want that building should be demolished. This is one of the reason. This is the reason why you want the demolition. So therefore, if you want that, then you will have to file a suit and recover your possession. That for you, this is a different cause of action.
No.
For the municipal corporation, if that is brought into their notice, they will take their course of action permissible under law.
But they have not taken anything, your lordship, till date, your
That they may not at this stage because it is at your behest. When there is a suit pending between you. So
respect. They have not even.
So that means in the considered opinion of this court, you are taking a recourse to get a decree through the municipal.
No, your lordship, I'm not before this honorable court, your lordship, to claim that my land has been grabbed, your lordship. Not even, your lordship, I'm before this honorable court.
Who is for the municipality? Name soon.
Before that, my lord,
Huh?
what is his right? Who is he?
No, he might have a right. Don't ask that
He
question.
don't have any right.
Attorney
Where is
holder,
that?
your lordship.
There is
Huh?
no environmental right.
You
Because
are the
he-
attorney holder of whom?
The legal hires of the Bideshi Gwala, who is the owner of the land, your lordship.
Who died in the meantime?
The respondent side, your lordship.
they are not a party here.
Over the my land, your
Oh.
lordship. They died. Respondent number 3, respondent number 4, and respondent number 8 died, your lordship.
Why power of attorney has filed this?
Lordship.
Why power of attorney?
Because they are the layman, so they have appointed the petitioner, your lordship, as a power of attorney holder, your lordship. I have annexed the attorney, your lordship, the power of attorney.
We'll take up this matter next Thursday.
Next days, they take it. Days. Well, your lordship, on 12th, I have 2 matter fixed. It will be on 13 or
Not
10,
13 thereafter.
14.
14 is just holiday.
Friday, I think.
Lordship, then
17. 17.
That
Please
will be-
this matter on 17th of who is for the municipality? Who is respondent number 1? Who is for the municipality? Municipalities made a party?
Lordship,
Who is representing the municipality? Notice served?
sir, Lordship,
Anybody appears?
on the last occasion,
List this matter and they will, on that they will verify all this. Yes, they are on a 17.
respond number 2, Your Lordship.
One thing, my lord, here, three petitioners died now. And three respondents, my lord, 3, 4, and 8.
Main writ petitioner likho. Hard learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner that during the pendency of this writ petition, who died?
4 and 8.
Respondent number 3, 4, and 8 expired. Respondent number 3, 4, and 8 expired, and therefore the learned counsel for the petitioner wants to substitute the legal.
No, petition has been filed, but no notice has been given.
Notice not issued.
Is it necessary for a notice? Under what provision?
Otherwise, who will contest now?
Will issue a notice for implement.
Implement has been done.
No.
Oh, sorry, ma'am.
Notice, no. Notice on section 5 has not yet been issued, only pending before the court.
See, according to this court, when it is a writ petition, these technicalities are not applicable. CPC is not made applicable for this. This order 22's limitation, these are not applicable in writ petition. What's the accordingly? IA, what is the IA for implement?
Your Lordship. Section of 5 Limitation Act, Your Lordship.
No, forget about section 5.
13755, Your Lordship.
Where is the application for implement?
It is 3756, Your Lordship.
3756. The present application is filed for substitution of the legal years of respondent number 3, 4, and 8 in their place in the connected writ petition, that is WPC 5728/2022, as the said respondents has in the meantime expired. First up, consider the pleadings in the application as well as the pleadings made in the writ petition. First up, after consideration of the said, this court is of the view that any orders that may be passed shall adversely affect the legal years of the respondent number 3, 4, and 8, and therefore they are necessary parties to be substituted in place of respondent number 3, 4, and 8. Full stop. Accordingly, the present application stands allowed. Present application stands allowed in pleading the aforesaid respondent as reflected in paragraph 4 of the present IA. Full stop. Present IA. Full stop. Okay. The learned counsel for the petitioner is to furnish an amended cost title in terms of this order passed today before the registry, as well as to the learned counsel representing respondent numbers, remaining respondents, so that the remaining respondents can also incorporate it in their record the amended cost title. Full stop. After amendment of the cost title, registry to issue notice in the writ petition to the newly implemented respondents, which shall be returnable after 4 weeks. Full stop. Accordingly, the present IA stands allowed. Full stop. In view of order passed in IA 3756 to 2024, 2023, no separate orders need be passed in the other IS. Full stop. बाकी के टाइलर लिखो, in view of the order passed in IA 3756 2023, this IA stands disposed. Now come to the writ petition. Full stop. In view of order passed in IAC 3756 2022, let a notice be issued to the newly impeded respondents returnable after 4 weeks. Returnable after 4 weeks. Petitioner to take steps for issuance of notice to the aforesaid respondent through register post as well as through usual mode within 5 days from date of incorporation of the amended cost title. Full stop. The petition petitioner is to furnish the amended within 5 days.
Much obliged.
Chalo. No, all what abatement, repetition, all disposal.
34.
Yes, let us understand how much time will you take and how much time to reply. As it's a Friday, Mr. Das knows. Isn't it, Mr. Das?
Yes, Madam.
Yes. So that we can deliver the order on Monday.
It's 2 minutes.
Why you need 40 minutes?
The
Very
reason-
limited issue. These are
Yes,
the
Your Lordship.
clauses whether on that ground you could have been.
The only issue why I'm saying I require hardly that's 2 minutes things to show that why it has been rejected and it could not have been rejected.
Okay.
But what has fallen from your lordship on that day, the scheme of the act, it's a.
No, that we are not going. That we are satisfied.
And
What is
therefore,
the?
and therefore it is, I want to make my submission on 2 aspects.
But these are not your pleadings in the repetition.
Readings are to the.
Admit it. Admit it. Admit it. Your case is structured in altogether different manner.
Substantially complied.
Substantial compliance, and that you have been discriminated.
Yes.
This is your case. So
Yes.
confined to that only.
Yes, your lordship. And whether that labor license was actually required on the basis of which they have rejected my bid on that day, on the submission of the bid. To that extent. I
Yes,
have
these 3 points.
The lordship. The lordship will kindly come to page.
So we have seen page 55, clause 2A3.
Yes, your lordship.
Okay.
Yes, your lordship. And your lordship will kindly come
Just
to.
a minute, huh?
I'm sorry.
Page 49. Yes. Yes, now we'll go to.
Lordship will kindly come to 31.4 at page 50 itself, your lordship.
31.4.
In fact, I don't want to start from clarification of bids because those things your lordship has gone through it. So therefore, I'd like to stay on 31.4.
31.4.
The bid, as your lordship got it, the bid evaluation committee shall examine the technical aspects of
Just
the bid.
a minute, just a
I'm
minute.
sorry, your
3,
lordship, I'm sorry.
Okay. Yes.
The bid evaluation committee shall examine the technical aspects of the bid, in particular to confirm that all the requirements of the bid documents have been met without any material deviation, reservation or omission. Number 31.5 now. The bid evaluation committee shall regard as bid as not as responsive if it conforms to all the requirements set out in the bidding documents or contains minor deviations that do not materially alter or depart from the characteristics, terms, conditions, and other requirements as set out in the bidding documents. That is, there is no material deviation or it contains errors or oversights that can be corrected without a change in the substance of the bid. Now, 32, your lordship, provided that a
30,
bid
30.
32 non-conformities, errors, and omissions.
Okay,
your lordship.
okay.
Provided that a bid is substantially responsive, therefore I'm using the word
Yes,
substantially.
that ground you have taken.
Yes, your lordship, because of this reason, your lordship. Substantially responsive, the bid evaluation committee may waive any non-conformities in the bid. Provided that a bid is substantially responsive, the employer or authorized representative may request the bidder submit the necessary information or documentation within reasonable period of time to rectify non-material non-conformities or omission in the related to the documentation requirement. Such omission shall not be related to any aspect of the price of the bid. failure of the bidder to comply with the request may result in the rejection of the bid. I'll pause here for a moment, your lordship. Now, your lordship, it is admitted from the perusal of the act and the rules and two judgments, I'll place it, your lordship. The Puja Association, another judgment, I'll place it to my satisfaction, your lordship. Sorry, to the satisfaction of this honorable court, that labor license is a license which is required and essential. Sorry, it's a subsidiary requirement. It is required only after you are awarded with the work in issue. It is post award of work.
Yes.
In fact, the CVC guidelines also mandates that. I'll place it before your lordship.
Yes.
Now, if your lordships kindly come to page 58.
Page 58.
That is the supplementary informations that is of my writ petitions, your lordship.
Just a minute.
I'm sorry, I'll go slow, your lordship.
$58
of my writ petition. This is section 4 bidding forms.
58.
Section 6, sorry, bidding forms. Has your lordship got it?
Hmm.
Now, if your lordships comes down below form qualification 4, license for executing anti-termite works.
Just a minute.
1, 2, 3, 4, 5, 6, 7, 8, 9. Form qualification 4.
No, you are reading at page 58, table of forms.
Yes.
Okay. Now you which one to?
Form qualification 4. Licensing. The serial
License
number.
for executing anti-termite.
Then license for executing firefighting works. Execution of minimum quantities of works. And above that, satisfactory completion of electrical works.
Where do you say that?
Just above anti-termite works.
License for firefighting, minimum quantities of work.
Then above that, anti-termites, above that.
Above that, satisfactory comes the electrical works. Yes.
These are the license I need to submit at the time of submitting of my bid. But it does not say submission of labor license. It is their own document. I'll just turn to page 63, your lordship. Sorry, 64. Now page 64, your lordship.
Page
64. Small a.
Just a minute.
I'm sorry.
64, small a.
For prime bidders.
Just a minute.
64.
Page
64.
And
there is a heading for prime bidders in bold on the left side. In the
yes.
Name of the bidder. Number A. Do you possess valid electrical license for executing the electrical works? Then down below. This is something I have to submit with my bids. Not only the license, but the details of everything. Now again down below, your lordship, form qualification 4. License for
form qualification
4. Down below, after that tabular form.
That we have seen.
License for
when you for a prime bidder you want to show the
electrical license is required. I have to submit
electrical license.
Then down below again, your lordship, on the same page, licensing for executing anti-termite works. Then they ask me, do you possess a valid license? I have to answer it. And the next page is page 65. License for executing firefighting works.
Yes.
All these licenses I need to possess and I need to submit it at the time of submitting my bid. These are essential terms and conditions of the contract. But nowhere it specifies that you need to submit a labor license prior to submission of the bid with respect to the establishment. That's there, Your Lordship. Now, page 307, Your Lordship, will come. The impugned rejection.
Just a minute.
Yes, yes.
Page 58. Yes,
If Your Lordships kindly come to page 307.
307.
NHS 6.
307.
NHS 6.
This is the impugned decision.
Yes, Your Lordship. May I read it, Your Lordship? Before I read it, Your Lordship, I'll read it, Your Lordship. The bid process management committee meeting is held today on 1/7/2024. This date is very important. Your Lordship will kindly mark the date at 1400 hours in the office chamber of the Director, Assam Animal and Veterinary Department, Husbandry and Veterinary Department, Guwahati 3, for the following works floated by NIT dated such and such and NIT dated such and such. We are bothered with the NIT dated 23rd February 2024.
NIT dated
23 February 2024, not the other NIT. Now I'll read the second para. On the outset of the meeting, the chairperson welcomed the members and requested the member secretary to proceed with the agenda. The member secretary explained the purpose of the meeting and informed that as per the minutes of the bid process management committee meeting dated 15/3/2024, shortfall documents were asked from Medicos Engineering, Sipsagar, Joyantokhaun, Triveni Complex, Adabari, such and such, against NIT dated such and such. Accordingly, bidders have submitted the documents and findings are as follows.
Where do you get this committee meeting 15/3/2024?
I could not get hold of it, Your Lordship.
That is not record, madam. You are mistaken. This is a Xerox copy of the minutes. Record is something different. How it proceeded, how it was placed. You have given two Xerox copies. These are not called records. Records is called where your file. We want that record.
Now, 4 dates are, I'm sorry. Now, 4 dates are very important, Your Lordship. 5/3/2024, that was the last date of submission of the bid.
Last date was?
5/3/2024, Your Lordship.
Just a minute. Five 3/24 last date.
Yes. Now, they have opened a bid on 15/3/2024.
Opened.
The bid on 15/3/2024. Now, that was the penalty 1 day prior to the imposition of model code of conduct. Why I'm saying so? Because I'm alleging malafide, Your Lordship. Therefore, I'm saying so.
Are you seriously arguing the malafide?
I'll
see. We have no problem. If you are seriously arguing the malafide, then it will be take a different course. Who is representing the respondents, parties?
Friend is representing.
No, individual. Malafide against whom?
Malafide against the department, Your Lordship. Against the
Malafide cannot be against department. Malafide should be against individual. He
Yes.
should be named. He should be a party by name. Where is that?
Your Lordship, the private respondents are there. I'll if that is
No,
something-
Mr. See, if private respondents, who are private respondents? These committee members.
No.
If no, how against whom can you say malafide?
Why I'm saying so, Your Lordship, then I'll drop that argument. What I'm trying to say is that on 15/3/2024, the shortfall documents
You
were
show us for the time being without malafide that this decision was arbitrary.
I'll go by that.
Go by that. Then we will come to, because then many questions will come. Malafide proof is something different. Malafide allege you'll have to give sunsays, you'll have to give many things. Then we may not wait for all this.
Okay, Your
Then
Lordship.
we may vacate the stay order and proceed, allow them to proceed. Yes.
Your Lordship, the next page 308.
Hmm.
Consulting engineer NG non-responsive.
308, huh?
Non-responsive as the labor license is valid for.
That's clear. They are clear that this
That
is
is
labor.
clear. Now, Your Lordship, will see that page 307, number serial number 2. Medicos and engineering Hatipoti Sipsago responsive. Submitted up-to-date EPF challan as shortfall document.
Okay.
In my humble submission, the EPF challan cannot be up-to-date, Your Lordship. Because it is deposited monthly as per the act. So definitely they have not submitted it time of submission of the bid. And number 3, joint account submitted up-to-date EPF challan and labor license in favor of department as shortfall documents.
Where is the clause as regards deposit of EPF? That same clause?
Yes,
along with
that same
labor
clause,
license?
that same clause, Your Lordship. It says up-to-date EPF. Now, Your Lordship, in my humble submission, my first leg of submission is that I am not required to submit the labor license with respect to the work prior to the submission of my bid. In fact, I cannot. Your Lordship, let us just try to understand it like this.
Yes.
What is the scheme of this act? The contract labor regulation and abolition. The scheme serves two purposes. Either you abolish it and regulate it. Abolition is provided under section 10 wherever your Lordship is very thorough with that. So I'll just place one judgment with respect to that. Yes, 1994.
Pa- 1994.
1994, 5 SCC 304. Para 3.
5 SCC
304.
304. Paragraph.
Paragraph 3, 4, and 5 and 6, Your Lordship. R.K. Panda. From the provisions referred to above, I'll read para 4, Your Lordship. Page 309, I'll read. From the provisions referred to above, it is apparent that the framers of the Act have allowed and recognized contract labor, and they have never purported to abolish in its entirety. The primary object appears to be that there should not be any exploitation of the contract labor by the contractor or the establishment. For achieving the objects, statutory restriction and responsibilities have been imposed upon the contractor as well as the principal employer. Of course, if any expenses incurred for them or any amenity to the contract laborers or towards the payment of the wages by the principal employer, it is entitled to deduct the same from the bill of the contractor. Now, if your Lordships kindly come to next page. The 6th line from above, again in Dinanath. Again in Dinanath versus National Fertilizers Limited, the court pointed out that the aforesaid act has two purposes to serve: to regulate the conditions of the service of the workers employed by the contractor who is engaged by the principal employer, and to provide for abolition of the contract labor altogether in certain notified process operations or other works in any establishment by the appropriate government under section 10 of the Act. It further stated that neither the Act nor the rules framed under the central government or any other appropriate government upon that abolition of the contract labor, the laborers would be directly absorbed by the principal employer. So the very object of the Act is to see whether the amenities are required to be provided or provided or not. Now, if your Lordships kindly take up the Contract Labor Abolition Act. Section 2, your Lordship. Definition. 2C, contractor. In relation to an establishment means a person who undertakes to produce a given result for the establishment other than mere supplies of goods of manufacture to such establishment through contract labors, or who supplies contract labor for any work of the establishments and includes a subcontractor. Number E, establishment means any office or department of the government or a local authority or any place where an industry, trade, business, manufacture. We are not bothered with Roman 2, but we are bothered with any office or department of the
Yes,
government.
one. That we have already
Yes.
Yes.
Now principal employer. A argument was being advanced that principal employer is the director. But going through these definitions, the principal employer will be the persons under whose jurisdiction the work is being carried out in the district. That is the joint director or additional director, whoever that person is. I'll read it, Your Lordship. 2G. Principal employer means in relation to any office or department of the government or a local authority, the head of the department, the head of that office or department or such other office as the government or local authority as the case may be specified in this behalf. So, number 4, Your Lordship, this was not read, I think. In any other establishment, any person responsible for supervision and control of that establishment.
So here principal employee in any other will not come in your case. It will come in relation to any office or department of the government or local authority. Here tender has been issued by whom?
Tender has been issued by the director.
Director. So the work is relatable to the department.
Department in an argument was being advanced by the department that work, the establishment is the site where the work will be carried out, right? No doubt to that. But who will be the in charge of that site?
So establishment means any office or department of government.
Yes, Your
or
Lordship.
local authority.
Yes, Your
So it can be any office,
Yes, Your Lordship.
office where the office is situated,
Yes,
or it can be the department itself,
Yes, Your Lordship.
or the local authority. We are not concerned with the local authority.
Right, Your Lordship.
Okay. So when it is department, it can be the establishment, can be department
Yes,
in a
yes,
given
no
case.
doubt, no doubt, Your Lordship.
Okay.
No doubt about it.
Principal employer means in related to an office or department, when it is department of the government.
Department will indicate Assam Animal Husbandry and Veterinary
And
Department.
department.
Yes. And
The head office or the department or such, this will depend upon the actual fact situation.
Yes, Your Lordship.
This determination is not specific.
Yes, Your
Yes.
Lordship. Now, if Your Lordships kindly comes to
Now, in case of certificate of each of you, the employer certificate is by the director.
Yes, sir.
So it will depend upon given facts. So director is the employer.
Right. No, I'm not saying that. In fact, as per the tender documents, the principal employer has already been defined.
So then why are you reading?
No, what I'm trying to say is that it is not necessary that each and every case,
No,
the head of the
it's
department.
or and or. It
Yes.
will depend upon the fact.
Facts and the circumstances of the
facts.
case.
Employer is defined in tender, which clause? Principal employer? Mr. Das, how much time will you take and Mr. Nath?
It should not take much time. Firstly, I'll just clarify 2-3 arguments made.
No, that will clarify later on. How much
Yeah.
time will you take? You just note, let him complete his.
Hardly 15-20 minutes, Milo.
Okay.
I'll make a submission with regard to the act and the rules also. That will take hardly, Milo, 10 minutes time. And rest, Milo, 5 minutes, I'll just clarify the factual position with regard to the NIT, Milo.
Okay, and not. Okay. Okay.
Your Lordship, employer is defined in page 52.
Yes.
52, section 3.
Yes. I will go it left. Just I'm taking it note down. Yes. Next, proceed.
The Lordship will kindly come to now section 11, appointment of the licensing officers. The appropriate government may by notify, I'm sorry, has the Lordship got it?
No, yes. That I have read 3-4 times these provisions to clarify myself. Because I myself was confused. That's why all these questions, I don't hesitate that I'm confused to say, so that we need clarification. These sections I have read almost 2-3 times. Section 10, section 11, 12, then corresponding rules, everything. Okay, just so therefore you need not read as a whole. You just interpret what is the provision.
Your Lordship, section 11 categorically defines two things.
Hmm.
It first of all, it says the licensing officers has to be appointed for the specified area.
Hmm.
It means there is a licensing officer for the.
There is already notification. Where is that notification? Mr. Nath, you have given it to us.
Yes, last day.
You have given. But whether it is still.
It is 13th of February 2013.
I have a copy.
It is somewhere I have gone through also.
Yes, yes, yes.
This is
This is the copy.
This is okay.
Your Lordship, section 10 says, why I'm reading these sections only to indicate that what is the requirement of the labor license. Your Lordship, section 10A says that a license.
Oh, rightly, wrongly, they have issued a notification. And in that notification, they have jurisdiction, they have given to whom and in what manner. So we cannot say that this notification is bad in this proceeding.
Commissioner of Labor has not been given the authority.
Huh?
Commissioner of Labor has not been given.
Maybe we are not going to the.
Just clarify one thing, Lord. The license has been given, the signatory authority, Lordship, or the office of the Labor Commissioner. The additional Labor Commissioner Assam, he is the additional Labor Commissioner, the second in the hierarchy from the office of the Labor Commissioner.
No, whatsoever, this notification has been issued in exercise of power under subsection 6 of section 11 declaring something. This may be bad.
This is not on a challenge.
This may be bad. So we will accept what it is. Until and unless we'll have to deliver it is under challenge. We are not on that. We just wanted to know when is the notification issued, and this is the copy, that's all. We are not going to deliberate on correctness of this notification.
Section 11 specifies the licensing officers and section 12 says the manner in which the license has to be given. So I'll just read that. Subclause 2, subject to the provisions of the Act, a license under subsection 1 may contain such conditions, including a particular condition as to hours, fixation of works, and other essential amenities in respect of contract labor as provided by the government and shall fit to impose accordance with the rules. It means it has to be project and work specific.
Which just
12.2 indicates, Your Lordship. 12.2 of the 1970 Act.
Section 12.2.
Subject, shall I read once more?
Yes.
Subject to the provision of this Act, a license under subsection 1 of may contain such conditions, including in particular condition as to hours of work, fixation of wages, and other essential amenities.
Okay.
In respect to the contract labor as appropriate government may deem fit to impose in accordance with the rules. It clearly indicates the special amenities, essential amenities, Your Lordship. Suppose let us assume that Sibsagar is a malaria prone area. So the licensing officers will go visit it and see if the requirements are what. And then that will be specifically mentioned in the license. And therefore it has to be work specific, project specific. Number 13, Your Lordship. Grant of license.
Section
13.
1.3.
Yes, Your Lordship. That same page. Every application for grant of a license under subsection 1 of section 12 shall be made in prescribed form, that is form 4, and shall contains the particulars regarding the location of the establishment, the nature of the work, operation or work for which contract labor is to be employed, and such other particulars as may be prescribed. Your Lordship, the wordings are very clear. Now, let us assume that I have been awarded the work. I have handed over the site. I'll go, I'll make an assessment that how much machineries I require, how much labors I actually require. Then I'll go and apply for that application.
Yes.
It only indicates that, Your Lordship. Then number 2, Your Lordship, the licensing officer may make such investigation, it says so. in respect of the application received under subsection 1 and in making such investigation, the licensing officer shall follow the such procedure as may be prescribed. Number 13, a license granted under this chapter shall be valid for the period specified therein and may be renewed from time to time. It is of no use, your lordship. Now, 16 to 19, it provides the amenities that are required to be provided. Now, there is a catch, your lordship. What sort of amenities has to be provided depends upon the numbers of workers. They cannot say you set up 10 canteens, you set up this, you set up that. Only after the numbers of laborers have been indicated therein, they can go and then visit an inspection and then see what is required. Which also clearly indicates that this has to be a work specific and after the work is awarded.
Okay, then.
Then, your lordship, the liability of the principal employer and responsibility for the payment of wages, I don't want to go through that. Then
rules.
Your lordship, there will be an inspecting staff also, that is not relevant in this. Now your lordship will kindly come, if your lordship is holding the same book, the rules, the central rules, that is.
No, we are not interested in central rules. We are interested in the state rules.
Yes, your lordship, but what I wanted to show something, your lordship, that why it is project specific and after work. I'll just show one thing, I'll demonstrate before your lordship that how the license.
Before they tell us, section 35, I think, empowers the state to have their own rule.
Own rules.
So, say state will have their own rule.
Exactly, your lordship, the rules will be framed under the act. So what is the basic purpose of the act? That's I
we have seen it. But I do not think the rule, central rule is applicable or any relevance in this regard. State may frame their rule into the specific conditions of the state, not in derogation of that. And we are not here to decide whether this applicable or this is good or bad. We'll see what as it is. Yes.
That's what I'm saying, your lordship. In the central rules, the form says I have engaged, which shows
we
that.
want to see what is the rule says in the state.
Yes, your lordship.
That is see.
I'll come to
Mr. This may be my bad habit, I do not know. But thing is that which is relevant, let us go to that only.
Okay, your lordship.
By no stress of imagination, we can hold that there will be a binding thing upon the state as regards rules is there. And that if there is any contradiction between central rule and state rule will prevail. This is not the case because it's an independent rule making power. Everybody has made their rule to the specific condition. So there is no relevance for central rule. Why should we waste our time? Yes,
the lordship will now come to the state rules.
We are on state rules.
Section 21, application for license. Every application by a contractor for grant of license shall be made in triplicate in form 4 to the licensing officer of the area in which the establishment is located.
Yes, I have marked it.
In relation to which is a contractor is located. Number 2, every application for grant of license shall be accompanied by a certificate of the principal employer in form 4 to the effect that the applicant has been employed by him as a contractor in relation to his establishment and he undertakes to be bound by all the provisions of the act. So, your lordship, it's the reading of these two provisions makes it very clear that after the work is awarded, only then I have to go.
No, not only then. If they may say, if you file a tender, you file a deposit. They say that we want a labor license for this work.
Propose to engage.
Yes, then also they can give a certificate. We are proposing to engage him.
Yes.
He will give this. This is a proposal. So not only engage, even proposal to engage, they can give a license to us work specific.
Your lordship, that has to be after the determination of the technical bid. It cannot be prior to that.
We do not know. They may say, okay, along with this, this is a proposal. We are proposing to engage. Maybe it's not necessarily that what should be the stage.
I would
that should be said in the tender notice. Of course, that you will have to have a license.
Yes. Now, section 23, your lordship. On receipt of an application, on receipt of the application, and as soon as possible thereafter, the licensing officer shall make such inquiry as he considers necessary to satisfy himself about the eligibility of the applicant for the license. Now I'll come to 1A, 24(1)(a), Your Lordship. Where the applicant for the license was
1A, there is no 1A in my book. Refusal and grant,
24(1)(a).
23(1),
No,
and
24(1)(a), Your Lordship.
24, okay.
Ah.
24(1)(a), okay.
When where the applicant for the license was holding a license in regard to another work and that license has expired, the licensing officer, if he is of the view that the amount of the security deposited in respect of that license is directed to be refunded to the applicant under 31, may on application made for that purpose in Form 5A by the applicant adjust the amount so that the refunded towards the security required to be deposited in respect of the application for new license, and the applicant need not deposit such case only the balance amount. This again goes to show that it has to be work specific, Your Lordship.
Yes, next.
Next, page 288, Your Lordship, 25(9),
25,
small Roman 9, Your Lordship.
25 Roman 9.
The licensee, has Your Lordship got it? The licensee shall within 15 days of the commencement and completion of each contract work submit a return to the inspector of area appointed under section 20 of the Act, intimating the actual date of commencement or as the case may be of completion of work in Form 6A. So therefore, this license has to be only for the work in issue, Your Lordship. Now that day, Your Lordship has pointed out section 32. I'm not going to that.
32. Yes.
Temporary, which also indicates that it can be done. I'm not going to all that. Then 42 and all those things are for the purpose. And I'll come to Form 4, Your Lordship. That is page 308. The dictionary tool, huh? Your Lordship has rightly pointed out 3 and 4 of the Form 4. Particulars of the establishment where contract work is to be employed. Name and address of the establishment. Type of business, industry, manufacture, occupation which is carried on in the establishment. Number and date of certificate of registration of the establishment. Name and address of the principal employer. Number 4. Nature of work in which the contract labor is employed or is to be employed in the establishment. Duration of the proposed contract work, given the particulars of the proposed date of commencing and ending. Your Lordship, this commencing and ending, why I'm stressing on that, it has to be after the award of the work. A question has fallen from this, from Your Lordship, that it can be at the time of the contract also. In my humble submission, it cannot be, Your Lordship.
In the contract, there is a time period.
Yes, Your Lordship.
So that will be proposed time. If you want extension, then that can be given.
But that has to be post. I'll demonstrate it.
These are not very relevant at this point of
Yes,
time.
Your Lordship. Then Form 5 and Form 6, Your Lordship. I'll not go through it. Now, Form 5 says propose to engage. Now, what is the dictionary meaning of propose to engage? Mark the next page. If Your Lordships kindly turn to page 583. The definition of propose, the meaning of propose has been stated therein. Right side, third, Your Lordship. 583. Has Your Lordship got it?
Proposal, propose, yes.
Propose, to put forward for acceptance or consideration. To nominate for admission or appointment. To intend. It means, Your Lordship, there is not much difference, Your Lordship, between the propose to engage and engage. It means I have engaged him.
You want to say engaged is an work order is issued?
Yes.
Propose is a proposal when we have taken the decision.
Yes.
And subject to condition, if you give it, we'll engage you.
Yes.
So that propose. This is your
Yes,
argument.
yes, Your Lordship.
understand. Yes. So according to you, this certificate can be only after award of the final determination of decision, award of the contract,
Yes.
and starting of the work. Yes. Yes.
2018. Yes. Have a move to. It will be there for property. Your lordship, on the last question, it has been to be here, no? Mojumdar Enterprise. Your lordship, I have handed over one judgment on the last occasion, Puja.
Puja, I have seen it.
Your lordship, the context is altogether a different issue. In that cases, the other certificates was being issued. But what was the finding of the court? I'll just try to read, your lordship, paragraph 9. In view of such provision of section 12 and rule 21, a bidder who intends to submit his bid pursuant to an NIT dated such and such would not be in a position to submit the required labor registration certificate at the stage of submission of the concerned bid. But at the same time, as noticed in the minutes of the technical committee dated such and such, the labor registration certificate of such and such was accepted to be valid registration. A further proposal of the said labor registration certificate produced by such and such indicate that it is a labor license granted to him by the such and such in respect of certain construction and repairing of the departmental works. Meaning thereby that the tendering authorities have interpreted clause 7 of the NIT to be such that any prior labor registration certificate would be acceptable to the authorities to the satisfaction of the requirement clause. Mr. Such and such advocate upon instruction stated that the procedure had been adopted by the authorities in order to ascertain themselves that the concerned bidder has the capability to provide the required labor registration certificate for the purpose of utilizing it in the contract. I have worked in the Kamrup district, admittedly on record. I have submitted that I have the capability. Such a procedure in the considered view of the court has to be made equally applicable to all the bidders, and it must also be made known to them that a labor registration certificate of any previous work undertaken would also be accepted. Otherwise, by mere reading of the expression labor license in the context such and such. Now, paragraph 12, your lordship. In the above premises, the court is of the view that ends of justice would be met if bidders who had intended submitted labor registration certificate
time to submit.
But however, it is provided that a labor license for a work as contemplated under Act of 1970 and the rules framed thereunder would also be required. The respondent authorities upon allotment of the work to the successful bidder shall have to follow the procedure prescribed therein for obtaining a license of work in hand. Now the next judgment, your lordship, 2019. Yes, your lordship. In this case, the technical bid of the person was rejected because he has not submitted a labor license.
What is the ratio?
মই এবাৰ পঢ়ি লওঁ, তাৰপিছত আপোনাক কৈ আছো। Citation to কৈ দিয়াচোন। Para 11, your lordship. On going through the impugned letter dated such and such, it is seen that the technical bid of the petitioner was rejected during evaluation of the technical bid on two grounds mentioned herein, namely no past experience of executing similar contract work involving 188 laborers and 9 tractors and financial incapability to undertake such work. Relevant portion is stated such and such. Now paragraph 12. From the above, what is evident that the technical bid of the petitioner was rejected on the ground that certificate submitted by the petitioner was either expired or did not carry the details of the employment of more than 60 conservancy staff for the year. The certificates provided by the station headquarters Dinjan only mention about the experience without details of manpower and financial capabilities. Therefore, it was concluded that the certificate did not show capability of the contractor involving 188 laborers and 9 tractors. The second ground, I'm not on second ground. Now, if your lordships kindly come to paragraph 19. Section 13 of the 1970 Act provides that an application for grant of license shall be contained.
Just a minute.
I'm
not
sorry.
getting page 19, paragraph 19. Yes, section 13, yes.
Section 13 of the 1970 Acts provides that an application for grant of license shall contain the particulars regarding the location of the establishment, the nature of the process, operation of work for which the contract labor is to be employed, and such other particulars as may be prescribed. It is evident therefrom that a license of contract labor is relatable to the work for which it is being sought, for which and such a license can be obtained horse work order for the work in questions. So it says so that only the work order is to be obtained and thereafter I can obtain the license. Therefore, to say that certificate submitted by the petitioner expired or did not carry the details of the employment would hardly have any relevance. Only after being offered a contract, the tenderer can obtain labor license from the labor commissioner containing the details of the employees to be engaged in such contract work. So that the pertinent questions which has fallen, that it has to be work specific and a post award of work. And the third thing I would like to place your CBC guidelines to be able to CBC guidelines protocol there. If your lordship, I'll kindly hand over the CBC guidelines. I'm sorry, your lordship, I flag marked it because only one thing I need to show there. Page 74, I have marked it. Has your lordship got it?
Yes.
Pre-award stage. These are the conditions for the pre-award stage. Now down below B.
Down below
B, post-award stage.
post-award stage.
Has your lordship got it? Agreement is complete. Agreement is page number, bank guarantee, insurance policies, labor license.
A, B, C. Where is the labor license?
Number 4, serial number 4 at page 75, top.
Yes.
Insurance policies, labor license, performance guarantee are taken as per the contract. So the CVC guidelines also says that labor license is required only after the works are being awarded. It cannot be at the pre-stage.
Okay. That's all?
No, your lordship, I have other more one more submissions.
Yes.
That whether this condition is essential or subsidiary. And if the tender evaluating committee or the author of the bid documents intends to read something or interpret something, that has to be specifically stated there in your lordship. 2010, 13.
Madam, we are giving you back it to back. This is available everywhere. If not required, it will require. See, these are part of these repetitions. Everybody has annexed it. We want how the process proceeded in the file. We want the record means the file. Mr. Nath, is not it? No, it's request. Not today. Not today. You give it on Monday because you have deliberated. I want to just see it. That for that we do not need a hearing.
Take the record on Monday.
Yes.
Your lordship, I'll refer to one judgment 2013 SCC 364.
On what subject?
Your lordship, whether these are essential conditions or collateral subsidiary conditions. Paragraph
Which paragraph?
28. Paragraph 28, your lordship.
Paragraph 28.
Paragraph 28, 29, 30, 31, 33, 34.
Paragraphs just tell us. 28.
28, 29, 30, 31, 33, 37, 38, 39, 40, 41. I'll read. Datta Associates has been referred in this case, your lordship. I'll read para 37, your lordship. Page 375.
Page 37.
Para
Para
37,
37.
page 375. Para 37. This observation, has your lordship got it?
Yes.
This observation made by the court in such and such rather come to an aid of ion exchange in the case. Since IRCTC did not clearly stipulate in the instruction to the bidders or in any special terms and conditions or in the prescribed procedure schedule or in any other part of the tender document that the tenderer will not offer any discount or the prices quoted by him in any such discount is offered to the tenderer will be rejected. The offer of the discount on the price made by ion exchange cannot be treated to be in breach of the essential terms of the conditions of the tender. To hold that the state or its agency can reject a tender for breach of a term or condition in the tender document, which is not explicit in the tender documents, is to give room to the state or its agency to arbitrarily reject tenders even where there are clear terms or the condition of the tenders are not complied with. Then Datta SSS has been referred, your lordship, in para 38 and para 41. I'll just read, your lordship. Page
Where?
376.
Page 376, paragraph
41.
Paragraph 41 is, okay.
The language of clauses 1 and 2 of the note quoted above is clear that the prices quoted are to be lump sum.
Paragraph
41.
41.
The language of clauses 1 and 2 of the note quoted above is clear that the prices quoted are to be lump sum, inclusive of all duties and taxes, etc. And vendor should indicate total excise duty amount included in the prices for plants and equipments. The note does not indicate the consequences that will follow if the vendor does not indicate the total excise duty amount included in the price for the plant and equipments. The note does not say that if the vendor does not indicate the total excise duty amount included in the price of the plants and equipment, the offer of the vendor shall be rejected. In absence of any mention of the consequence of the rejection of the offer for not indicating the total excise duty amounts in rupees included in the price of plants and equipments in the tender document, the High Court could not have held Ion Exchange as committed a breach of essential terms of conditions of the tender document or the tender format. For the above conclusions, we are again supported the decision in Kanhaiya Lal versus Union of India, which was relied by G.J. Fernandez State, where a condition is essential or collateral could be ascertained by reference to the consequence of non-compliance thereto. If non-fulfillment of the requirement results in rejection of the tender, then it would be an essential part of the tender. Otherwise, it is only a collateral term, your lordship. So in this case, they have not said that we require a labor license from such place or all of Assam before the submission of the bid. They say the labor license. Now, the labor license has to be understood in the terms of the validity of the act and the rules, your lordship. And your lordship, Kanhaiya Lal is also on the same issue. I'm not reading it, para 6. Now, your lordship, Datta Associates, I would like to refer.
That I have read, that's why I have given you the judgment.
Yes, your lordship, the Datta Association and Podda Steel Corporation is also on the same line. It says that, I'll just read Podda Steel's once, your lordship. The requirement is a tender notice and it can be classified into two categories. Para 6, your lordship. Para 6, page 276.
I have already read. That's why I have given you the judgment on them.
Then I'm not reading, your lordship.
Not necessary. Many times I have read this judgment. This and Jasper's Long.
Yes, Jasper's Long is on 2 counts, your lordship. There cannot be any hidden criteria. And
yes.
I'll read one.
Not necessary, not necessary. Those
Yes.
are.
I'll read, I'll refer to two judgment that hidden criteria, paragraph 90.
Not
the
necessary.
Jasper's.
Not necessary.
I'll not read, but.
See, it's rely on a judgment which is apt.
Your lordship.
If one judgment is apt, why should we write that Mr. Sinha has relied on 11 judgments?
Right, your lordship.
That's all. We don't have luxury of that much of time reading and reading. You might have a satisfaction that I have relied on 10 judgments.
Nothing like that, your lordship. I'm just
So,
placing the.
see, if a principle of law is applicable, what we want? We want a principle of law. That principle of law is clear in one judgment. That's enough.
Now I'll refer a judgment which is says that in the tender works, obviously, your lordship, the court cannot interfere. I'm not on that. But if it is hit by Article 14, if there is arbitrary.
Which judgment?
Reliance Energy Limited and another, your lordship, 2007-8 SCC 1.
Best is the MP Power Corporation.
MP Power Corporation is the latest one, your lordship.
That is the latest one. It covers all these
All
judgments.
these judgments,
That's
MP Power
all.
Corporation, which says that in the statutory.
Sum and substance, even in statutory, non-statutory cleanses.
Yes.
And earlier, all throughout, it was said that when it is non-statutory, you cannot touch. Now, it has said that even non-statutory, you can touch in the touchstone of Article 14. So, this is the basic fundamental principle that if there is Article 14 that restrain, self-restrain
Yes,
upon
sir.
the courts in non-interfering all these decisions,
Yes, your lordship.
then there is no bar. So that is the principle of law. That is any one judgment will do.
53 to 75 and para 82, your lordship. So in my humble submission, your lordship, I'll conclude my submission with one thing, your lordship, that I have substantially complied. I'm saying so. I should have said I have complied. Because in terms of the section.
What is your case? Is it your case that this is not an essential condition? Or it is a case that I have substantially complied?
Your lordship.
You have argued both.
Yes.
You argued that this is the form, this is the requirement, this is not essential.
This is essential post award of contract, your lordship. It cannot be prior. to that.
Therefore,
Yes, your lordship.
this is not essential
This is
for the
not-
purpose of technical bid.
Yes, your lordship. That is my submission.
That is your argument. So therefore, this is not an essential condition. This is one. Alternative argument that even if it is held that this is an essential condition, your whole argument is that this is an substantive compliance in as much as the certificate they are insisting is even if not permissible because in terms of the law, act and rules. This is your two arguments.
Right, your lordship.
That's all.
And one more, I would like to say it's hit by section 23, I don't know, of the Contract Act. Suppose, your lordship, a bidder of the document cannot insist on something which is forbidden by the law. So section 23 of the Act says that what considerations and objects are lawful and what not. The consideration of or object of an agreement is
So you are
lawful.
saying that this is an impossible condition which you have given, so it should be read down to be any license.
No, I'm not saying it should be read down. I'm saying it should be, it cannot be pre-award of stage. It has to be post-award stage.
So that
they are
we have
still-
already recorded.
Yes. In my humble submission, your lordship, that impugn minutes of the meetings should be set aside and further they may be directed to open my price bid, your lordship, because a state exchequer is also involved and BSN Joshi has categorically stated that when a tender works are being awarded, the state legacy has to be followed and the one which is most economically viable has to be taken into consideration, your lordship. Joshi to be. I'm deeply obliged, your lordship.
Monday, there is a meeting.
Fine, no problem.
Since she'll have bring the record, we'll make it CAV on Monday, deliver the judgment within
Actually,
by the end of the week.
fine, no problem.
Paragraph to
Okay.
liquidity, paragraph to liquidity.
Okay. Your Friday is free now.
I reached Guwahati 4:15 in the morning, my lord.
To argue this case.
Yes, went to Arunachal, then returned by train.
So you take
Sleepless
rest.
night.
So you take rest.
I'm good.
As Mr. HK Das is feeling tired, this matter stands up and we listed on Monday. Okay. List this matter on Monday for concluding argument of Mr. HK Das and Mr. Nath, and for production of the record of the, what we call it?
Minutes of the meeting. your
Not
lordship.
minutes,
Record
record of the
original
tender
records.
committee, original
Tender
record of
evaluation committee.
Relating to the tender procedure.
relating